Mentions. 801. One.
Lordship, this item is listed on 25th. We request
25th September 23.
25th.
Tentative list is 25th of July.
Yes,
You
Lordship.
don't want it to be deleted. Not to be deleted.
803 Milords have filed this transfer petition seeking transfer of custody case filed by the respondent.
We gave liberty to the husband to file an application for visitation rights. How can you say I won't appear?
Milords, what Kolkata courts have done is that they have directed me to appear in person before that court. Milords, whole purpose of transfer petition would become infructuous if I...
When is the date fixed by the...
July, they said, Milords. That is day after tomorrow, Milords. That is the reason I moved this application.
Tomorrow.
Much obliged, Milords.
I think 804, the computer generated date is not showing.
804 is yours.
Lordship, on the last occasion, the last order, it was directed to be listed after 2 weeks, but the computer generated date is
within
Lordship, any date.
any date, 4 weeks, 6 weeks.
My lords, I seek my lord's permission to file an application in a matter listed tomorrow, my lord.
You're for the respondent, is it?
Tomorrow, my lord, tomorrow.
Tomorrow for what reason?
My lord, the matter is listed before your lordship tomorrow. I seek my lord's...
You are not in number 1.
What are you mentioning? Item 1 has been called.
I'm mentioning a matter listed tomorrow.
No. What do you want?
Seeking my lord's permission to file application in a matter listed tomorrow. Grateful.
The one first case pass over.
First item pass over.
What's appearing for the petitioner in this matter?
Is it incomplete?
My lords.
See that the service is completed. As per the office report, the respondent is yet to be served. Await service of notice.
We'll take certain steps, my lords.
Fresh steps may be taken for effecting service of notice.
Deeply obliged, my lords.
Interim order to continue. Pushte bhi nahi hai. List after service completed.
The service complete.
Item 3. Item 3. Awesome. ये दोनों खत्म कर सकते हैं.
कर दें, अभी कर दें.
Yes.
I am appearing for the respondent. I have filed the counter affidavit in this matter. 4 litigations are pending between the parties. 2 are pending at Agra.
He will argue first, is it not?
Lordship, this is a transfer petition for the transfer of the
Ahmedabad to Shahjahanpur. Very well. Your counter is basically on merits. What do you have to say about the prayer for a transfer?
maybe transferred at Agra.
Maybe transferred? Agra. You're going to Agra for 2 cases by the looks of it.
For 90 days is more convenient.
Your DVC is at Agra?
Lordship, that time I
Your 125 CRPC petition is at Agra. So in any event, you're going to Agra.
at that time I was pursuing nursing course. The nursing course has been
But those cases are still continuing at Agra, is it not?
completed in
Those cases are completed.
cases are still pending at Agra. 2 cases.
Case is pending, but my nursing course is completed.
That does
You're
not-
going to Agra to attend to those cases. One more case you can attend.
See, I will try to transfer the
It is
Shahjahanpur.
more convenient to
I will try to transfer that cases in the Shahjahanpur.
Well, you've not done it till now.
Yes, sir.
Then, when did you complete your course?
Complete in July 2025.
2025. This month you completed your course. You file a rejoinder then, if you. And counsel for the petitioner shall file a rejoinder to the counter filed by the respondent. List on 18th August, 19th August.
particular date.
For petition. 19th August.
Item 5, I appear for the petitioner wife, my lord.
Right.
Husband, and I've taken instructions.
Matters are not filed in both the matters. Second matter is a fresh one.
Chandra is not filed, the other matter notice
He is seeking transfer of your maintenance petition.
My lords, may I suggest? I've taken instructions and I've spoken to the client. It's just a 2-year-old marriage with 1-year-old child. Maybe
You want to settle it?
if it can go to
Mediation?
We are willing for it.
Mediation order. When will you appear before the mediator?
My lords may keep it online because she used to travel from Bangalore.
Online, first hearing online. After that, you'll have to abide by what the
My lords,
mediator says.
I've taken instructions upon that also. My
Depositing.
client is willing to pay for the airfare for both the mother and the child and 1 night overnight stay over here, my lords.
my
But
lords,
whatever it is, the mediator will decide whether you need to come physically. As and when the mediator requires your physical presence, please be there.
Be grateful, my
28,
my lords may record
before the
we are willing to deposit
the respondent husband offers to bear the expenditure of the petitioner wife and the child for their to and fro traveling expenses and also their boarding and lodging at Delhi for the purpose of attending the mediation counseling.
Should it be physical, my lords? Should it be
The
physical?
first hearing will be on 28th July,
Virtual mode, my lords.
online.
I'm grateful.
First one online, thereafter as decided.
I'm grateful, my lords.
Keep going.
6.
Also service.
Service is complete, ex parte order.
answering. Lordships are allowing it.
So grateful, deeply.
Lordship, in this matter, I am in custody since 2020.
PW 17 has already been examined. The trial must be more or less over.
And all are examined.
Trial is more or less over. It's a 302 case, is it not?
Lordship, on the parity.
The trial is more or less over. Why should we let you out on bail?
Lordship, no, Lordship.
How many witnesses are there entire? The total list of witnesses.
I think just
It will not do. You need to know. You find that PW 17 has already been examined.
kindly pass over the.
This kind of half-baked preparation is not good, counsel.
Please pass over the matter. I have a judgment as well. Please. Kindly pass over. Lordship, I could not file the online appearance. Kindly take it.
Which matter? For Passover also, you want an appearance to be recorded?
You've undergone only 7 years.
But your lordship may see the witness. There are 6 defense witnesses. None of them has been considered.
It's not the state.
Papers who has consistent.
Where is the evidence of PW2 saying that the FIR should be lodged against unknown persons?
Your lordship is.
What basis have you taken that ground?
See,
FIR names you.
I named me, but before
Then?
that they have called at 5:30 a.m. to the police officers.
Who says that? The IO says that.
I see.
Where is the IO's evidence? Deposition.
Page number?
Your lordship, it is recorded in the trial court itself.
If you're going to start searching for it now,
Page 34.
yes.
The defense side,
Hmm.
second paragraph, the learned counsel primarily argued that on morning incident so-and-so, the complainant's son Prem Shankar informed police via mobile number and
Out of the blue statement. On what basis does he say this?
may see page
Some
35.
phone call made to somebody, and in that phone call, what conversation was made? How does he know about it?
Page 35, next page. Page 35, witness PW6 investigating officer Ramesh Chandra Sharma in chief examination stated that on 18/6/2013, based on the information received from mobile number Prem Shankar, recorded under entry number so-and-so from control room, it
He
was
doesn't say anything about unknown persons here.
is written. It was informed that his uncle has been murdered while sleeping in a hut. In cross-examination, this witness confirmed that the phone call had reported that the Prem Shankar uncle has been.
That's all.
But
Where is the mention of unknown persons?
that call at 5:30, he has not mentioned anything.
There's no basis for your statement.
Lordship may give me some time. I will produce the PW6 deposition also, your lordship.
To have filed it, because the sentence which you read out doesn't support you. What is the point of raising a ground without having any supporting material? Every case will be developed as we put questions to you. That is the unfortunate practice followed by counsel in the Supreme Court. You put a question, then you think of what possible answer you might come up with. I want time to produce that material. What is this system of arguing a case?
Sorry. Your Lordship may at least consider that there is no eyewitness they have falsely implicated.
No, there is a question.
court.
Yeah, appeal is pending. No, appeal is pending.
Appeal is pending, Your Lordship.
Appeal is pending.
Appeal is
pending. Not a case for
Then Your Lordship may allow me to withdraw it.
non-counsel for the petitioner, having argued for some time, seeks permission to withdraw the special leave petition. Special leave petition is according to this practice also. I don't like it. Arguing and then withdraw. Yes.
My lord, it's simple matter, my lord, where the victim has died.
You at least file an application for recalling of the arrest warrant? No. You just abuse that process. Arrest warrant is issued against you as long back as on 2/2/24. And you just ignore it. Proclamation proceedings initiated, stayed by the High Court. But that doesn't mean that the arrest warrant will get wiped out. At least an application should be filed for recall of the arrest warrant. Where's the question of you're asking for anticipatory bail when there is an arrest warrant pending against you? Anticipatory bail means you are anticipating arrest. There's no question of anticipating here. There's already an arrest warrant out.
What has happened is, my lord,
That arrest warrant being recalled, and that too, this is not even a case where the arrest warrant is issued during the pendency of your anticipatory bail. Those cases at least perhaps stand on a better footing. You are not in that category. Your anticipatory bail is rejected, arrest warrant is issued, then you file a fresh anticipatory. Once that arrest warrant is there, you're not entitled. Even if the husband has been granted regular bail, this kind of ignoring the procedural norms, we can't condone that. Sorry.
in the husband and the father.
Husband has been granted bail, but the arrest warrant against you still stands. There's no question of granting you anticipatory bail. Delay condone? We find no good ground and reason to condone.
I may be then permitted to withdraw the petition.
This other system of withdrawing after trying your luck is another unhealthy practice followed here. There's not some gamble before us. Try your luck and then back out. What is this system? We find no good ground and reason to interfere with the impugned judgment and order passed by the High Court, especially if petitions accordingly dismissed. Yes.
Please, Lords, I appear for the petitioner. Pursuant to your Lordship's order, I have joined investigation. Appearance has not been filed by state yet. However, counter has been filed by respondent number 2, the complainant.
Respondent 2 has filed.
Chief, my Lords.
Who appears for state of Punjab? Who appears for state of Punjab?
Anyone has entered appearance?
Yet entered, my Lords. If your Lordship has
entered appearance also.
Please, my Lord. If your Lordship
of the standing counsel. Standing counsel for the petitioner takes permission to serve notice upon the designated standing counsel for the state of Punjab. Based on 19.8. Interim order to continue.
Highly obliged, my Lords.
Lords, it's against suspension of sentence.
Yes.
In an NDPS Act wherein punishment was awarded for 10 years imprisonment.
And that the chemical which was recovered is used in making that drug.
So he has to explain why
Yeah.
he's holding on.
Yeah.
Issue notice returnable on 26th August. Service shall be effective.
Please,
This is the registrar, yeah.
this is a application for bail which was rejected. The petitioner.
15 witnesses examined. How many more to go?
Lordship, I must frankly tell your Lordship, this is a legal aid matter. We couldn't get instructions, but I checked up from the website the status of the trial court. Lordship, what I understand as per the status of the trial court that prosecution evidence is over and it's now pending for final arguments.
Then,
and may I just request Lordship one thing?
DNA evidence is also there.
May I just request one thing to your Lordship? if Lordship, because it's now in stages of final arguments, if Lordship can give some time frame.
No, we don't fix the time. So, but it's already reached the stage of arguments, then why do you need to delay condone?
Condone the deal.
We find no good ground and reason to interfere with the judgment and order passed by the High Court, especially petitions accordingly dismissed.
Much.
Yeah.
Yes.
Amount is deposited in your personal account.
Yes.
So how do you explain those entries?
Because the three things which I wanted to.
How much amount was deposited?
29. The total amount during COVID.
21.
50 lakhs. Now,
50.
one by one, Milords, I'll say. Milords, number one is that 41A3, Milords, the police.
Forget about it, 41A and all those things. You withdrew government money and you deposited it in your own account. How do you explain that?
I'll explain, Milords. What happened during COVID was that I was asked to conduct the election, to feed the candidates during the elections, number one. Number two, the other activities in Ranchi. So I had to, Milords, take out money, do it, whatever. It was like an army contract, Milords. There was no accounts being made. During COVID, total thing, Milords, I had to do. The DM used to come and pat my back. I'm doing a great job. This is one. Number two, Milords, is that...
Have any authorization from your superior? Put the money in your own account?
It was done, the audit report was done, the new BDO has come. And there's a criminal case, CBI case against the new BDO. Not that, I don't want to pick up, Milords, two wrongs don't make a right. Milords, may I take your Lordships to page 82, Milords. What happened was that the BDO complained before the authority, Deputy Commissioner. And the Deputy Commissioner, Milords, said that we'll hold an inquiry. I just filed an IA application.
You're a Nazir.
Nazir for the last 30 years in that district Nazarat, Milords. And he was a court clerk. He improved his grade by becoming a...
So notice returnable on 28th August. Petitioner shall not be arrested in connection with FIR number.
I'll just give it 1 second. It is in the first page, Milords.
41 of 2024.
Baliyapur Police Station case number.
Registered with Baliyapur Police Station. Subject to the condition that he joins and cooperates with the investigation. He shall also scrupulously abide by the stipulations by the conditions stipulated in section 482 within brackets 2 BNSS.
My lords,
14.
it is infectious, my lords. The petitioner is out on statutory bail. So can
Out on statutory bail.
Yes, my lords. So kindly.
Yes, those images, the videos and photos have been taken off. Are you appearing for the state or?
The state.
Please ensure that those photos, whatever he has uploaded, those are at least removed. He says that they have been removed, but we do not know. It is stated that the matter has become infructuous as the petitioner was granted statutory bail. Recording the said statement, the special leave petition is dismissed as infructuous. However, which state is this? Tamil Nadu. The concerned officials in the state of Tamil Nadu shall ensure that all photos / videos allegedly uploaded by the petitioner are removed, if not already removed.
My lordship, the counsel is in another court. Please pass over the matter.
So.
16.
Yes. Lord, I've been in custody since 31st of May 2016, 2024.
Should notice.
There was a recovery of C.
May I serve the statement?
28th August. Service shall be effected by all modes, including Dasti. Then council is also permitted to effect service of notice upon the designated / standing council for the state of Rajasthan.
Reference court has fixed 113 per square feet, which has been.
But it's still substantial, Miss Suri. From
100 and odd.
60,000, 90,000, you've gone up to 15,24,600. Even the reduced amount. No doubt from 49 lakhs, you've come down to 15 lakhs.
So far as 100, reference court is 113 per square feet, and High Court reduces it to 30.
Reduce it to 35.
35.
That is also substantial, though.
Commissions, my lord, that is. Your
What is the legal point that you're raising there?
Your Lordships may kindly see here the deductions have been given. In fact, one of the matters, my lord, pertaining on which we have relied upon, that is already, your Lordships have condoned the delay and issued notice on that, my lords. We are relying upon LSC 476 of 2013, on which the reference court has fixed. And then, my lord, thereafter remand, the matter has come up before your Lordships, in which your Lordships have issued notice. That's my first submission.
Different acquisition, though. Not the same acquisition.
Not the same, but in the same year, my lord, what happened for the ring road, 7 villages were acquired, my lord. 4 villages had come before your Lordships earlier, in which your Lordships have fixed the first village 187 per square feet, second village 150 per square feet, third and fourth village, my lord, 129 per.
This order refers to some remand order. It's a criminal case.
Pointing out, my lord. Or to that 476 of 2013, which has been relied upon in our case and fixed the market value at 113 per square feet, my lord. That matter was remanded. Thereafter, my lord, against the remand order, the matter has come here, my lord. Now, your Lordships may kindly see here what has happened is, my lord. For the 7 villages were acquired, my lord.
Come to ho gaya jada.
Very well. Issue notice. Issue notice returnable now.
113
Delay also.
35 per
8th September.
113 से एकदम 35 करते हैं बहुत drastic reduction also.
That is also bad. Delay. Issue notice on the condoned delay petition as well as the special petition.
Please, your Lordship. We want to show only 2 classes.
So according to you, classification
Could be because
has no legal status.
Lordship,
And you're saying it's not a change of law.
please see the class, my lord. I'll just show 2 classes, plain reading, and we'll leave it.
Page
there.
143.
Please come to 37, class 9.1, and then 12.2c.
37.
7. Lord, this is a lump sum contract. The bidder shall.
You also accommodate the price change, the taxes change there. If there is a change of price.
So 9.1, it is a lump sum contract. Lord, these are all advantages somebody can take today at 10% and tomorrow and come and say bidder's price. So it's a frozen price in terms of it is not that, my lord, price plus taxes. Please come to 12. There is a price variation.
Please come to page 143, Mr. Venkateswara.
It's only 1 class and then come.
Come to 143. What you are saying that it doesn't take into account taxes. Come to 143. Clause 3. Roman 3.12.2. In case of increase in duties / taxes during the scheduled delivery period, purchaser shall revise the prices as per the new duties, taxes for the supplies to be made during the remaining delivery period as per terms and conditions of the purchase order. So you were willing to accommodate the increase in taxes by paying the supplier if the increase in tax happened during the delivery period.
In what form is contemplated in 12.2? 1 minute, Lord. Please come to.
You can't say that.
Class I want to show. 1 class, my lord.
Classification does not partake of legal.
Please come to 75. Well, 1 class we want to show. Only 1 class. With that we will rest. 12, my lord, it doesn't. I'll tell you the reason because.
It is not a change in law.
Not a change.
So according to you, classification has no legal backing at all.
Incorrect classification.
On the face of it, your argument.
Can you show the provision? 1 minute, 1 minute. Please come.
Just to put it mildly.
2.6.
If you say that a classification has no legal support, then every classification, then we can also hold it against you.
1 minute I'll show and then, my lord, I'll rest.
Your arguments in the other matter were on the ground of classification. And now you're saying that classification has no legal standing.
Lordship may see 1 minute the class and then say what I want to say. 12.2.c, my lords may see. At 75, my lord has. Yes. My lord, what is the scope in increase when it comes
This is exactly what is there at 143.
In case of an increase.
The expiry of the delivery date.
In case of an increase in duties, taxes during the scheduled delivery period, the purchaser shall revise the prices.
This is what I read out at 143, Mr. Venkatraman, except for the page difference, you're reading the same clause.
Used this, one. Prices as per new duties / taxes for the suppliers. Therefore, it is not, my lord, somebody wrongly classifies. Lord, I'll tell you the reason why this is. I quote it at 100. and show 10% as my price and say 110 as my
I
value.
can't say that the excise department is wrong. Therefore, I will not go by their classes.
That entire. Tomorrow increase it by 2.5.
Sorry.
Come back and say reimburse the 2.5%.
Delay condoned. We find no good ground and reason to interfere with the impugned judgment and order passed by the High Court.
Oblige, Your Lordship.
Especially petition is dismissed. Yes.
My lord, I am. My lord, I am appearing for the applicant.
Very good. Yes.
My lord, here, my lord, if my judge, the district judge in page 104, my lord, says that without giving opportunity to others, so no suit or appeal should be dismissed.
One moment.
On this. And the High Court, my lord, and the High Court in para 14 arrived to a definite finding that they were aware of the fact, my lord.
And they don't file till 24. Notice order.
I'm for the respondent.
You'll have to explain this. From you entered appearance in the other side's appeal on 28/10/21, and then you filed this appeal on 12/7/24.
2024.
Showing you indulgence is one thing, but this is literally taking the legal process for granted. You will wake up at your own convenience whenever you want, and all delay should be condoned because the mills of God and the government grind very slowly.
There are issues with respect to merit as well.
My lord, kindly say the further proceeding before the trial court, appellate court, my lord.
Delay condoned, issue notice, returnable loan. There's only,
my lord,
you're taking notice for both the
my lord, further proceeding may be.
Sorry, my lord, number 1.
My lord, further proceeding may be stayed, my lord.
Stay taken. Are you taking notice for both the respondents? Airport authority is one, the other one is.
The other is the Tehsildar. Do not have instruction for.
Tehsildar. Mr. So-and-so learned counsel takes notice, accepts notice on behalf of respondent number 1 and waives for the notice. Service of notice shall be effected upon the unserved respondent number 2. In the meanwhile, the further proceedings pursuant to the impugned order shall remain stayed insofar as the appeal filed by respondent number 1 is concerned.
My lord, I'm grateful, my lord.
20.
Item number 20 and appearing for the petitioner in this case, my lords.
Yes. You wanted to withdraw the case?
Yes, my lords. I will be withdrawing the case at liberty to approach the bank for OTS.
There is a question of you offering 63 lakh to settle the entire thing. Your outstandings are now over 2 crores. 50.
My lord, already the bank has sold my property in 60 lakhs, whereas my term loan was for 80
One
lakhs.
property is sold doesn't mean that your entire account stands settled by virtue of that. That is your misunderstanding.
I stand corrected, my lord. I pray for withdrawal of the matter.
Very well. There's nothing that we can do with this. Once you ask the High Court to allow you to withdraw.
So much.
Ground and reason to interfere with the impugned judgment. SLP is accordingly dismissed.
May I just request for a passover, my lords, in 20?
So,
okay.
It to sealed cover only has to be returned.
Yes, my lord. Appeal is of my lord.
Registry is directed to return the sealed cover received from
The assistant registrar, my lord.
the assistant registrar. Yeah. Assistant registrar.
That has been given in the
due and proper acknowledgement.
Your Lordships, I am appearing for the original petitioner in item 22. We also have no objection to the opposite party receiving a copy of the.
It can go back. Why should we retain that seal cover? If at all the registry has kept it. If at all they've kept it, this order was passed long ago, 2018.
We have no objection, Your
If
Lordship.
at all it's available, say that also, if still available. Then again, you'll file a contempt case and say that they've not returned it. You wake up at your convenience. The registry is not under a bounden duty to retain all your records for all times to come. Where are your objections stated 9th December 2004? 24?
24, Lord.
9th December 24. Your objections.
It was mirrored in 19.
9th December 24, which is referred to in the order.
Yeah.
That's the date of your objections. Where are those objections?
Objection before the consolidation court, my lord.
Giving you the date 9/12/2024. This is also against him, so he doesn't file it.
We raised the objection before the court of consolidation.
Answer the question. Which page will we find your objection stated 9/12/2024? You have not filed it because it is inconvenient for you. That is the document relied upon by the High Court to demolish your case. So you have conveniently chosen not to file it.
I have it in the next week. I will file it.
Question. On that simple ground, we'll dismiss your SLP. This kind of selective filing of documents, unfortunately for you, will not work.
Not so. Not
There is the document then.
certainly.
That document indicates that you are not who you claim to be. Your date of birth is different from your Aadhaar card, and your name is also different. So now this person is now, these nephews are coming out of the woodwork as we go along. You're for the Gram Sabha.
My name was mentioned.
For the state.
Sundan Singh alias Chandrapal Singh. And that
Convenient, but date of birth gives you away. 20 years difference between the dates of birth of the person who filed the objections and the other person. So
that was examined by the court of consolidation, my lord.
we find no good ground and reason to interfere with the impugned judgment, especially petitions accordingly dismissed. This is a batch matter, so it will go along with it. The office report is there.
I filed it.
Individuals, so many batch cases. So that office report, the order is there. You want the same interim order?
Same. So
Tag along with. 25. Decision might have been taken. The 6/6/23 order fixed a timeline of 4 weeks to take a decision. Is it decided or is it still open?
Yes, my lord, it is decided.
Then where is the question?
Let me now.
You wanted an opportunity of hearing. For some reason, the division bench was of the opinion that you should not be heard.
So,
but if the decision is already taken, you have a fresh cause of action.
First cause of action is precluded. That's what my grievance is.
Who prevents you from challenging it? You were not heard.
That
doesn't mean that you cannot challenge it.
Grievance is that. My lord, simple observation of dismissal of the disposing of this SLP is more than enough for me. My lord,
we'll have to give full liberty then.
My lord, because I was not made as a party because of the. My lord, my lordship's one line will do. What I'm saying.
That is the question.
For
why do you need to have our permission to challenge an order? You can always file a petition, say that the very fact that the division bench order mentions your name shows that you have some role to play, but you were excluded from the hearing part of it.
Exclusion by a application, my lord, that is a judicial order by writ appeal. Now that the writ petition is pending before the single judge. My lordship's observation.
What observation do you want from us?
That I can make my objection in the writ petition itself or
file the writ petition, the other person.
He was permitted to hear. There are two aspects of it.
File an impleadment petition there and challenge it.
I have been running the institute for.
Once it has become infructuous, we are not opening windows and doors here.
That's what I'm saying. My lord, kindly bear with me for a few seconds, my lord. My lord.
So you can file an implead petition. You don't need that permission from us. The Supreme Court is not here to give these opportunities for you to go before the High Court. That is exactly what we are being reduced to. Make an observation here, make an observation there.
My
what is the?
Is correct. I have filed a review petition.
If you had come within time, before the 4 weeks period was over, before a decision was taken, then we would have directed that you also be heard. That is over. Your review was dismissed.
Review, my lord. Thereafter, I
And the review was dismissed after nearly 2 years. What were you doing all that while?
No, my lord. My review is by just, I have filed against the SLP 2 orders.
13th February 25 is the date of dismissal. It was pending for 2 years.
That is High Court, my lord. That is, my
You know that 4 weeks time is granted. You file a review and allow it to remain pending for 2 years. Obviously, you killed your own case. What is the review petition for? After the decision is taken.
My lord, now my.
No, it is not for you to, for us to advise you.
I say this much. May I
Say
say?
is also that this is just a last ditch attempt. 612 days delay in filing.
It's a.
Sorry, counsel.
My lord, give me 1 minute. 1 minute of.
We've heard you long enough.
Because on merit.
You've already pointed out how you murdered your own case.
Lordship, may kindly see the Annex 14 for a second. My writ petition was the first writ petition for the distance reason. My lord, these are the centers. As per the scheme, each center should have a 2 kilometer distance. Here
You're not on the merits of the matter, please.
That's what I'm saying. My writ petition was the first one.
There is substantial delay of 612 days in the filing of the special leave.
That is because of the.
They're not inclined.
We have a reason to say, my lord.
The SLP is directed against 2 orders. The initial order dated 6/6/2023 and the review order dated 13/2/2025. The initial order dated 6/6/2023 fixed a timeline of 4 weeks for the authority concerned to pass a final order. Having filed a review petition in relation to the said order, the petitioner allowed the said review petition to remain pending for a period of nearly 2 years, which effectively concluded the case. We are now informed that pursuant to the direction in the order dated 6/6/2023, a fresh decision has already been taken and the same is subjected to challenge by another party before the High Court. In these circumstances, we are not inclined to condone the delay and entertain this special leave petition, which, on the face of it, has become infructuous. The special leave petition is accordingly dismissed. However, the dismissal of this special leave petition shall not preclude the petitioner from invoking such remedies as are available to him. Law.
I'm grateful, man.
Yes.
Please, Your Lordship.
Mr. Sudhanshu, 8/11/1949 sale deed never challenged.
Not proved it. That's the only contention we have.
We are not going to go into this. And the other brother, Balu, seems to have sold a lot of other properties at Vanpuri.
When is this?
Here is the question of your saying, no, he was not given property at Vanpuri, he was only given at the other place. What is the other place?
Password.
He sold other properties at Vanpuri. You never challenged that 1949 sale deed. No.
But that was not acted upon, Lord. That was.
We find no good ground and reason to interfere with the interim judgment and order passed by the High Court, especially a petition is accordingly dismissed. This also. Go on.
Notice was issued under
Section 14 appeal. The wording of Section 14 itself indicates there's no need for an 80 notice.
reserving Lord, the government
We're just trying to delay condone. We find no good ground and reason to interfere with the interim judgment and order passed by the High Court, especially petitions accordingly dismissed. This, I think we need to order notice. 77 crores. You're on caveat. This matter perhaps will
may I just say this?
We'll order notice. We'll order notice and hear it.
The only issue is of my lordship may keep the issue of maintainability open because ultimately, my lord, this is a fact-based
We are not
analysis.
saying anything. We are just issuing notice and we will hear the matter. But now perhaps you're required to return that amount.
You've already paid it, not without
They paid it.
Very well. Then very well. Issue notice returnable on. We'll give you a Tuesday's date so both of you can be prepared for final arguments.
Well, we may need 6 weeks to just
We'll
file.
give you a long date, 9 September.
Can I
9th
request,
September.
my lords, can I request for the week after 9th? my lords?
Which is, my lord, brief submission.
Brief notes may be filed by both sides, not exceeding 3 pages. Before that, who is taking notice?
Respondent number 2, my lords.
You are for only for respondent number 2.
20 Sabo, my lords.
That's 1.
Yes, that's one.
It's 2.
Regulatory commission.
Sorry, regulatory commission. So the commission is only a pro forma part.
Yes, my lord. In any case, we will take the same.
Very well. Mr. So-and-so and Counsel takes notice for respondent number 1 and waits for the notice. Service of notice shall be effected upon respondent number 2 by all modes, including this. 9th September, we'll take it up for hearing then.
Can you just keep on the week after that, my lords? Can I?
Oh, you want a week after that?
Yes, my lords.
16th, we already have 2 hearing matters fixed. So 23rd then.
I'm obliged.
Please, Your Lordship. But the reasoning at page 6, my lord, that it should be within 500 meters goes contrary to the stand taken by the, my lords, the director. Lordship may kindly look at page 56. It clearly says poultry related activities and related construction activities are exempted completely. My lords, Your Lordship.
You are trying to club both the cases.
That's one.
That can't be.
I'm not on that point, my lords.
Then-
I'm not on clubbing. That's an independent action. Fair enough. Let go now. The issue is, my lord, Your Lordship. See the reasoning at page 6.
The other side file, where is the question? Now the authority is directed to take action against you.
The issue is something like this. Poultry related activities are totally
It is for you to go before that authority and demonstrate.
Finding will hurt. My lords.
Where is the finding?
The lords may kindly come to page 6, my lords.
Yes. Yes. Page 6 is the contention.
Yes. Page 6, my lords, is Your Lordship may kindly come to page 6. Sorry, my lords, I have a problem. Yes. 16, my lords, paragraph 16. This is the content. Paragraph 16, my lords.
Paragraph 16.
Page 6, paragraph 16. I humbly submit that as specified in the Tamil Nadu Combined Development.
Who is this humbly submitting?
We are submitting. This is the stand taken by the director. Stand taken by the director, my lord's view says that in Tamil Nadu Combined Development Building Rules, no residential or commercial or institutional building shall be constructed within the radius of 500 meters from an existing crusher. This is what is the stand and which has been accepted. At page, my lords, Your Lordship may kindly to look at page 7. Since paragraph 5. Since the violations are already identified by the official respondents.
Not in reference to para 16. Para 16 is a party's submission.
It is
We don't know what the official respondent said about violations.
See, then my lords, page 5, a chart is given. Page 5 chart. That's why there's no specific finding as to what
Associated buildings, and it is found that are located as follows.
Exactly.
Very well, that is all.
And I
So
think
now the authority is directed to take into account whatever violations are there and take appropriate action.
I have today is my lord.
There's no identification here in this order as to whether it's within 500 meters, beyond 500 meters. There's nothing.
Really look at paragraph 5, my lords. 7, which hurts me directly. In case they have given a finding, it's fine. They have not given a finding.
Paragraph?
Paragraph 5, my lords.
Violations are already identified.
Violations are already identified. Now, yes, the High Court has accepted the findings.
No.
My lords, that's
You're reading both together. What is extracted in para 11, 16, these are from some affidavit of a party.
But then, my lords, at 5 it says that they have accepted, the court has accepted it. Since the violations are already identified, there is absolutely, my lords, no application of mind as far as these issues are concerned.
The authorities that they are not, you are not violated.
That's all. You need to go before the authority and
this finding should not
prove your case.
Today, my lords, yes. Authorities are going to take action because they will say that the High Court has already taken a call.
We find no good ground and reason to interfere with the impugned judgment passed by the High Court. However, it is pointed out that though the High Court directed the authorities concerned to follow the due procedure and take appropriate action in relation to the violations,
Alleged violations.
Violations said to have been identified by them, it would be open to the petitioner to demonstrate and prove before the authorities concerned during the course of hearing that such violations are not actually made out. Subject to the above liberty, the special liberty.
Lordship, it is settled law of this court that no land of any person can be.
No, first you please address on the issue how in a disposed of matter these MAs are coming. Under which provision of law?
And paragraph 3 of the order passed by the bench makes it clear that they did not want to go into subsequent events.
First you please answer my question. The which provision of law, when a case is finally decided, these MAs are popping up?
No, Lordship, it is not that.
File final review, you put a final review, but no. The case has been finally decided and you file MA under, I don't know, and the provision of law, I have yet to see that provision of law, and you revive the entire case.
Give me 2 precious minutes.
Sorry, please first answer my question.
Lordship, in this matter, when this case was decided by the Supreme Court bench, they had given a liberty to us to move a representation.
No, you can't read one paragraph divorced from the other. Go by, first come to paragraph 3 of that order, please. What does paragraph 3 say?
Paragraph 3.
How long will you take? Page 32.
Yes, Lordship. Paragraph 3 is, though it is sought by the to be submitted by the learned counsel appearing for the petitioner that there are some subsequent developments which have been taken place in respect of the land in question. We are not inclined to examine the same. But this
once that sentence is there, this clarification prayer that you have put forth, there's no question of even entertaining it.
That subsequent development was that Noida was.
That is exactly what the bench said they will not take into account. This miscellaneous application, sorry, this appeal under Order 15, Rule 5 of the Supreme Court Rules 2030 is completely without merit.
Then Lordship may, because the new
As the miscellaneous application filed for clarification is contrary to the order passed by this court on 21/11/2014.
Without even a single penny, we are going to acquire our land. So
The
Lordship,
appeal is accordingly dismissed.
give liberty to.
Appeal is accordingly dismissed. That liberty, whatever is there, you make use of that. We are not going to say anything at all. Sorry. It's 31.
Lordship may client object, please.
Item 31.
Because of this,
This order,
which I must state, say to
will issue notice.
Yeah, only thing, I had made a statement that on Friday, I'm examining because time has. So I put it to the client because our worry is.
What has elapsed?
A lot of time when the scheme has gone. So,
I
but
see.
my problem is entire banking sector is going to get ruptured, is just because of this reason. Yeah, Friday, if it can be kept, because
Friday.
stay on the merits of it.
Fair enough to say. My client is concerned.
You are appearing for whom, Mr. Manindra?
Respondent.
The company.
The bank in the same OTL took the money. It took the interim order of the Honorable High Court in 2002. Suggested and my other friend said that he not going to the merits to disturb us. He is only on the question of law, which I had not put in. So, my lord, at least
Let it be on Friday, because then again I will not have the leeway to put it on.
He just, Lord, at 217, this was an interim order of accepting the money to this amount, my lord. And that was without prejudice. So, the next step should be that this without prejudice will go and our debt will remain settled.
That is what I was mentioning on this point also. The simplicity, keep it on Friday.
As a
If it's
request
convenient to
counsel for the petitioner, list on give Friday's date.
Petitioner. Learned AOR is appearing through vision.
Maybe
Yes.
appealing for the petition in this matter. Lordship, in this matter, the summons has been duly served to the defendant, Lordship.
You did not take an exemption under Order 22
Lordship,
Rule 44.
No, Lordship, we were
The
not.
decree
We had
against
no
a
knowledge.
dead person is not binding.
Yes, Lordship, we totally agree in this matter, Lordship, but we are left with no remedy, Lordship.
No. That you
Lordship,
have
in
to
this,
work out your remedies. We are not
Lordship,
here
we
to
have no
advise
other
you.
remedy, Lordship, because we have a
We are
decree
not here.
against.
You can't take
Lordship,
a decree against a dead person and
No,
say
no,
that
Lordship,
I'll enforce
we
it
are
against
totally
his
agree, Lordship, in this matter, but we have duly served the summons
Look up
and
the
we
legal
had no.
position in 1979 3 SCC 578.
Lordship, it has been duly
Option is
served.
given to those LRs to say whether they
But
would be
they are
bound
not
by a
filing,
decision
they are not
against
coming.
their dead predecessor.
Yes, Lordship, they are not coming
or say
upfront,
that you
Lordship.
don't want to be bound by it.
No, Lordship,
If
we are
suppose
not.
the
They are,
decision is in favor of the dead person, the LRs can always say, yes, we'll accept the decision. But if it's against the dead person, they can always say, we are not bound by it. So
yes,
that's
Lordship,
the
but they
legal
are not
position
coming forward, Lordship.
laid down
That is
as
the problem.
gone back as in 1979.
Lordship, may kindly consider, remand the matter back, Lordship. Lordship, may remand the back.
Dismissed, counsel.
Please, madam.
This week, similar case we dismissed only, I think, last week. You buy property, you don't get your name mutated, then who is responsible? Your vendor takes you for a ride. Because anyhow, you buy the property and you go and sit in Canada. Then
After many.
you don't get your name mutated, how is the government responsible? Government will go by the land records. The name of your vendor is there. So they call him and he merrily goes and takes the compensation.
I see what the High Court says, page 3, about delay.
Anyhow, liberty is given to work out your remedies. Then.
Me is not given, my lord. Kindly see, delay is the delay and latches. May say, my lord, if I file a suit for recovery, my lord.
Petition was of the year 1981 and your petition is 2021.
Liberty is given. What do you mean liberty is not given? However, we leave it open to the petitioner to pursue his remedies against R5 if he has any such remedy in law.
My lord, say delay and latches, my lord. My lord,
Read.
what will happen, my lord? Kindly see, my lord, page 3. The petition is not only barred by delay and latches, but also not disclosed cause of.
Anyhow, this is left open to you. Make the best use of it that you can. There's nothing that we can do with this.
Let me proceed.
Sorry. Even here, after the case is over, 1109 days delay in filing.
Kindly see, my lord, he is not well, in fact, my lord. He is not well.
Please, you can't just wake up at your own convenience and say that I'm wrinkled. So once in 20 years I come. So whenever I wake up, let me enforce my rights. How is it going to work?
Sometimes it happens, my lord.
Sorry.
The real case, my lord.
Sorry, we find no good ground and reason to condone the delay of 1109 days in the filing of this special leave petition. Even otherwise, we find no merit in the matter. This condone delay petition and in consequence, the special leave petition are accordingly dismissed, reiterating the liberty granted by the High Court in the concluding paragraph.
Very great. Please, Your Lordship. Madam, my lord, I have mentioned about the document in my.
I want secondary evidence, but.
My lord, I have mentioned the document in my plaint, my lord. I have moved an application to produce the document from the defendant. Defendant says that he
doesn't have it.
He didn't found that, my lord.
But come to the document itself. This Hindi document, of course, the script is so small, I can't read it. But the translation that you have filed, come to page 33. There should be 2 originals.
6 originals.
Then what happened to all the other originals then? We have voluntarily signed this memory letter and handed it over to each other.
That is there, my lord.
All these copies which you handed it over, they're each of them an original. All of them are signed by you.
The office of the
What happened to your brother's documents? These are all amongst the brothers, is it not?
single brother, my lord.
So the other brother should have it then.
The brothers have,
Handed it over to each other.
there is a dispute.
So once the High Court is fully justified in saying this is not a fit case for secondary evidence.
Is relevant. It has been stated by the trial court that document is relevant.
The duty is on you to produce the original. You're not even trying to get the document from your brother.
The defendant says that he has searched the document. The document is.
Read the defendant. This document shows that there were more than one original.
Yeah, original was.
Once there was more than one original and the other original is with your own brother.
Yes, my lord. On brother.
Efforts did you make to get it from him? What efforts did you? No, this is a third party.
Not third party, my lord.
Person who has now become the partner, he is not the
He's my brother.
Qutbuddin Kanodwala is your brother.
My lord. Yes, my lord.
Initial settlement deed is with whom now?
With this one only, my lord. With this one only. My lord, may kindly see the annexure in this, the translation, my lord.
Abbas Ali is the one you had your initial partnership with.
Zakir Hussain and Kalimuddin.
Your initial partnership is with your brother Abbas Ali?
No. The Zakir, my lord, may kindly come to
Abbas Ali.
31, my lord. May kindly.
Do you know the facts of your case? Abbas Ali was the first partner, your brother.
There was a
After Abbas Ali came this respondent.
No.
And your settlement deed, who all are parties?
May kindly see settlement deed, my lord. That is at 31 page.
You don't mention the Abbas Ali is also there.
Abbas Ali.
Abbas Ali will have a copy of the document. Abbas Ali is no longer part of your litigation.
No.
Then what efforts did you make to get the document from Abbas Ali?
31 for a moment. 31, my lord.
We are looking at 31. Abbas Ali's name is there.
Zakir Hussain and Kutubuddin.
What efforts did you make to get the document from these other brothers?
My lord, we are the two brothers in the litigation right now, my lord.
Leave your litigation. All these brothers had a copy of that settlement deed because you said we are handing it over to each other. So all these brothers have the original document which was given to them. What steps have you taken to get the original from any of these other brothers?
Tried to obtain from
No, where there's no mention of anything.
My lord, once the document is admitted.
We find no good ground and reason to interfere with the impugned judgment. Especially petition is accordingly dismissed. Letter for adjournment. This personal difficulty will not do. You have to tell us what this personal difficulty is. Old system has gone. Your letters for adjournment should either mention health grounds, bereavement, or some genuine reason which we find satisfactory. So you can't just come up with this personal ground. What personal difficulty? What personal difficulty is there? Sorry? So you should say health ground then. Why do you say personal difficulty? Fever is a personal difficulty. Adjournment is sought on the ground of personal difficulty, but the learned counsel representing the learned counsel for the petitioner states that the learned arguing counsel is suffering from fever. On that ground, the matter is adjourned. List on 8th September.
Please, my lord.
This has to be. 4 of the FIRs are in UP, 1 is in Delhi. Why should they be clubbed?
My lord, because
You take people for a ride, each of them is a separate case. There's no question. Oh, that also you have to prove it.
My lord,
You're not inclined to entertain this writ petition filed under Article 32 for clubbing of FIRs. For clubbing of FIRs into different jurisdictions. In 2 different states, you say. The writ petition is accordingly dismissed. You want us to grant you bail in this writ petition, you say?
bail is rejected by the Allah.
There's no limit to hope, of course, but even such desires must be within some parameters. You can hope for the sky, the stars.
My lord, petitioner's father is running from pillar to post.
Sorry.
Bail, and there is already so many.
You have to secure bail, there's no question. Not for us to advise you what you should do.
Senior standing next to you.
You. The advice was that you should be consulted.
I was requesting him to consult you.
Yes, sir. Let's see, this matter.
Agmuthu, the bigwigs get off. And then the small wigs also say sympathy. So nobody is punished for corruption in this country.
Be punished. Your Atma kindly come to page 50 alone, Murat. I did not make any demand. Your Atma kindly come to page. Your Atma kindly come to page 50. Murat.
You've been inside now for 15 days, is it?
More than 1 month, Murat.
More than a month. There will be order notice. You spend some time inside. Think over your past deeds. Thereafter, we'll consider whether sympathy is warranted or not. We are not going to grant you bail at this stage. Issue notice, returnable on
in the bail.
26(8).
Notice on bail also.
Notice in the issue notice on the specially petition as well as the prayer for interim relief.
And service and
Matter, will it come up on a non-miscellaneous day? 20, not criminal matter. Aayega na?
service standing counsel.
Mr. B.I. Yes, sir. Sure. Permission is granted to effect service of notice upon the learned designated public standing counsel for the state of.
Item number 36, kindly take my offline appearance because I am unable to contact the AOR. He is out.
You're only bothered about the appearance. First appearance is the issue to be addressed. Very well. Appearance noted. Then in the previous matter, 37 and 36. Right. 38.
This is arising out of matrimonial disputes between the parties. I'd filed
FIR clearly indicates what happened, allegedly happened at Bangalore. Where's the question of the Karnal police investigating that?
I'd filed an FIR.
How will the Karnal police investigate what happened in Bangalore? You do not wish to travel from Karnal to Bangalore. So this entire investigation team of police officers will have to travel from Karnal to Bangalore now. Is that justified?
Allow me to proceed.
Incident which happened at Bangalore has to be investigated there, is it not? The Karnal police cannot investigate it in Karnal. So that means they all have to travel to Bangalore because you do not want to travel from Karnal to Bangalore.
I have the contents of
Sorry. We find no reason to entertain this. We find no merit in this writ petition filed under Article 32 of the Constitution of India, seeking transfer of an FIR registered at Bangalore to Karnal, Haryana. The incident, the alleged incident which led to the registration of the FIR occurred at Bangalore and would necessarily have to be investigated there. The writ petition is accordingly dismissed. 39.
Your Lordship, this matter is emanating from a marital discord.
The FIR is quite detailed and the allegations are also quite detailed.
Should the charge
Father-in-law and mother-in-law, but not a case for quashing though.
Lordship, they did not reside with the petitioners. They've resided in a span of 5 years of the wedding, of the marriage. They've resided with the
The
petitioners.
allegations against the in-laws are also quite detailed, whether you resided with them or not. Once the allegations are spelled out in such clear terms, you will have to face the trial in relation to those allegations. Not a case for quashing it.
Your Lordship, if you could take a look at page number 122, where the charge sheet.
Yes.
Yeah, Your Lordship, the allegations against the mother-in-law and father-in-law are very minimal. No independent evidence has been produced against them. No medical record.
That is very detailed. The unfortunate habit in the north is that the charge sheets are extremely cryptic. That doesn't mean that the case will only fall within the parameters of the charge sheet, which it never does. So,
FIR,
sorry, Counsel, we are not going to interfere with this one. We find no good ground and reason to interfere with the informed judgment and order passed by the High Court. Especially petition is, no, we do not hear two counsel in one case. It's not try your luck, then pass it on to the next. No, sorry. Sorry, if you had no faith in your colleague, then you ought not to have allowed her to argue.
Your Lordship, just one point.
Sorry, Counsel. This is not a fit case for quashing, though.
This matter.
This report is filed by Mr. Palli, giving the details of the cameras which have been fixed there. 24 cameras have been fixed. So the scope of this application is only with regard to whether you're all satisfied with the cameras or whether you think that more cameras should be there or some camera needs to be elsewhere.
One additional request.
We are, Ms. Guruswamy, you're not going to enlarge the scope of this.
But only this, that may we have access to the footage also. That's all, my lords. On this report.
The order.
Access to footage is all.
That is.
Are involved, Lord. You can't.
This is my son in question, my lords.
What about Mr. Palli's fee? It has been paid. Who was supposed to pay it? The 1 lakh?
Yes, ma'am.
has been
And the boarding and lodging, everything is over?
on boarding and lodging, his fees has been.
That's been fair. He doesn't need. His father may not be there anymore.
My lords,
He's in Jammu Kashmir. So, very.
Lords, would your lordship just
We're
consider?
not going to enlarge the scope of this. This has only come up for the acceptance. The compliance report filed by the court commissioner is duly taken on record, as it is stated that all parties concerned are satisfied with the number of cameras fixed and their location. The report is taken on record and the matter is closed.
Grateful.
The respondent number 2 has filed 2 criminal complaints against me. One is 921 and other is 452. Out of in 921, my lord, the matter reached up to the
Your MOUs also required this arbitration.
Well, this one can't
Say that I'll just pay the principal and be done with it. I will not pay any interest. You took this amount when? 2006 you borrowed this amount.
MOU was there and my lord, he was supposed to.
No, but the finding of the court is that the arbitrator is also your man, so he's not proceeding in the matter.
Change, my lord.
No, but then you ask for it there. You can't ask for the quashing of the cases on the ground that I've paid the principal of 2006. Therefore, I should be let off the hook.
I want to play something different, my lord. Kindly come to page 71 for a moment.
71.
This order of this honorable court, my lord. Or in the first matter arising out of 921, how I've been non-suited. This is simply filed by the respondent number 2 complainant, because the High Court allowed in my favor. And it is urged before we have that the memorandum of understanding, on the basis of which the High Court had recorded its finding in those documents, and that though no counter has been filed, the side has been taken before the learned trial
You
court.
take steps in relation to the arbitration, but you can't ask for quashing of the case at this stage.
I've already paid, my lord, the civil matter.
Paid what?
20 lakhs rupees.
That is what you borrowed in 2006.
The gentleman.
19 years later, you don't want to compensate him for the delay in repayment.
Supreme Court, he has come and say that those amounts
I mean that we are not prejudiced to the extent that you hope to prejudice us. You may have lied at that stage, but that doesn't mean that you walk away with just paying the principal.
Now the arbitrator will be about a matter. He will give the compensation.
Sorry, Counsel. We find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially petitions dismissed.
Right, please, Look, several things against me. The one.
No evidence that the land is ancestral. On the other hand, you seem to have bought the land after 1986 or around that time.
Was this that there are the only issue, according to me, there is
Mr. Alam, as you said, too many things against you.
Can I just take 30 seconds, only for counsel there. They wanted one little fact to be brought to your lordship's notice. Now, there are 2 IAs which have been filed before the High Court. Once in 2012, the second time in 2015. Both of those IAs with their records for filing of additional documents, along with the additional documents, are part of the additional volume before this honorable. Now, my lords, one of those at least has been allowed. The other one has been kept to be considered at the final stage, my lords. Now, my lords, there has been no consideration of the material that these 2 brought in. And one, if your lordships may just have my IA for a moment, my lords. Only just that. If your lordships are persuaded by that, and that is about all. Now,
which IA is that?
IA number is 167296, my lords.
Which page will we find it?
Referring to page 29 is the first page, if your lordships have that, my lords.
Of the additional documents.
Additional document, my lords. This is the first IA. It was kept pending. And if your lordship see, my lords, the prayer is at page 32. The top of page 32. Therefore, humbly pray that the annexed documents may kindly be ordered to be admitted as evidence of the applicants and may kindly be ordered to be taken on record. Now, the corresponding order in this, my lords, is on page 146.
Yes.
Plus, this says 17th August 2012, IA number so-and-so shall be considered at the time of final hearing. Reply of so-and-so. Now, my lords, this is the first IA. This is the first IA. The second IA, my lords, is on page 7. Another IA with additional documents. So the first IA is kept to be considered at the final stage. Page 7 onwards is the second IA. My lords, the prayer is at page 10. Please see that one. Okay. Page 11, I'm sorry, Manoj. Page 11. At the top, Manoj, it is therefore humbly prayed that the annex documents may kindly be considered to be.
This has been considered, is it?
If your lordships have page 147. This is the corresponding order in this. This has been allowed. Now, Manoj, both of these have not been considered by the High Court as my only thing. So the only.
What are the documents that you filed along with this?
I have filed, if your lordships will see, starting from page 50, the relevant ones are, Manoj, and unfortunately, some of them are in Hindi.
Jamabandi you filed. What does it show? Jamabandi is for the.
Please have page 58. Now, the predecessor in interest's name is recorded there in the fourth column on page 58. Center, Manoj, I'll just read that Hindi with Manoj. I'm very sorry, the English.
No, I can read it. Jaswant Singh Ji.
Jaswant
Rao Sajjan Singh Ji.
The admitted position is Jaswant Singh had actually transferred the lands to my father, who was Vijay Singh. Sajjan Singh. Sajjan Singh is the one from whom I am claiming my father. Because that's the admitted position. Now, please have the next page also.
No years are there. There's no mention of ancestral property.
The years also. Now, please see the next page, which is where the endorsement is at page 59. संवत 2007 मतलब I'll just read this. श्री राव जसवंत सिंह जी ने जरिए तहरीर खुद तारीख 26/10/1950 से अपने किस्से में अपने भाई बना विजय सिंह जी को भाई बहन के गुजारे के लिए दिया है. So this has been granted for मतलब their sustenance. इसलिए हसब ख्वाहिश कल अराजी 314 बीघा 8 बिस्वा अराजी के माल की श्री बना Mr. Vijay Singh ji ke naam wa hukum tehsil 8/11/1950. So there is an order passed on 18/11/1950.
How are you related to these people?
I am the son, Maloj, of Maloj, I'll just point out. Jaswant Singh, whose name is mentioned here, is my uncle. Is my uncle, and my father's name is Vijay Singh. Jaswant Singh and Vijay Singh are real brothers. That is the admitted position. Nobody has doubted that. So I am claiming under Vijay Singh. So all of these transfers are in favor, are through Jaswant Singh. So, and it records.
What other document do you have? Only one?
Have. The next document is at page.
This is not the Jamabandi though.
This is the entry of the transfer of the land in the revenue record in my name. In my predecessor.
And what does the Jamabandi show? The Jamabandi at least has some value. These documents may not really help you.
Chips have page number 26, Manoj, for a moment. 26 is in English, Manoj. This now relates back to 1952, 53, 54, 55, 56. So the land revenue which I have paid, the receipts of that are here.
Where is the Jamabandi?
See at the top, Manoj, at Vijay Singh's name is entered. Now Vijay Singh, Manoj, is...
What's the Jamabandi, Mr. Shoaib?
Jamabandi. It's part of the page 21 is where, Manoj, I'm...
21 is your application.
Manoj, please have page 21. The main SLP, Manoj, I'm sorry, Manoj, the main SLP has that. The second column, it records the name of Vijay Singh, under whom I am claiming today. And this is also an entry of 1st of May 1958. So all I'm asking is, Maloj, for a reconsideration of all of these documents before the High Court. That is the only limited thing. I understand, Maloj, that several courts against me, but Maloj, I'll have my day in court if all of these are seen.
Application is there. So applications have not been taken into consideration. Show notice on the limited ground as to whether High Court erred in not considering the additional documents filed under two separate IAs, one of which was ordered and the other was directed to be taken into, was to be taken into consideration. Another was to be taken into consideration at the time of final hearing. The order, full stop. However, the impugned order does not reflect consideration of such additional documents.
To be fair in one other thing, there is some huge delay against me. There was some issue with the lawyer. We had given it to the lawyer, Malots. There were some COVID issues after that.
How much is the delay?
There is
not noted the delay.
And
oh,
about 460 days in delay.
That is
I'll have to state that. Lordship may issue notice on that also.
Notice on the delay.
Lord, I'll issue.
Fortunately for you, neither of us noticed the extent of the delay. But with that kind of delay, perhaps you're just trying your luck.
I'll point out what.
Next senior, to be very frank with you, we wanted to dismiss it on the ground that it is not an ancestral line.
I have been fair, Manoj, some premium for being fair, number one. The second thing I can only say.
Very well. Issue notice on the pending delay petition as well as this petition.
Deeply obliged, Lord.
I'll correct the order. List on 15 September.
Request to kindly have a look at 43.2, my lords, because there's a main matter. 43.2 is what?
Perhaps this matter, Mr. Pava, will take it up for hearing on another day. This requires to be.
Request, whenever my lords feel appropriate.
This amount of 5 lakhs in each appeal has been put in a fixed deposit?
Deposit, my lords.
I think this requires to be. List on.
They've already filed a suit. And on the other.
The resolution plan is being acted upon. It's already implemented. You are for the applicant or the
Respondent RP, my lord.
RPs?
I have to place only one fact before your lordship, which might be worthy of consideration. While your lordships have not issued notices yet, in fact, in the order where your lordships imposed costs, my lords, your lordships noticed
details of suppression.
Reason, my lords, that this was a case of a Western hotel, my lords, in Calcutta. And there was, my lords, the Kanorias who had given the land and this was built. So now this slipped into this company, the subsidiary slipped into CIRP. So the question was that their plans, etc., the promoters, etc., were all thrown out long ago, my lords, their challenges all failed. A successful resolution applicant has come and has taken over, implemented, paid the creditors, etc., all done.
Everything's over.
The point was that in that area, some portion which was leased to this company, CIRP, continues. They tried to produce a fake framework agreement which was not registered. So the court then said, nothing doing, we can't even look at it. That was the first appeal. Second appeal before your lordships was that he says that there are computers, air conditioning facilities which are necessary for the hotel to operate are partly within the leased area and partly outside, because it was originally a subsidiary. They really didn't care much. But now that the plan has been approved and the new man has come in and taken over, they want to go ahead and disconnect it.
Can I?
What said, no, you can't do this. Otherwise, it will destroy this resolution plan. But we give you liberty in terms of para 11 to file a suit before the civil court and then go ahead and claim if you want increased rentals, if you want to work out something, go and file a suit. They came up in appeal. They suppressed the fact that it's pursuant to that liberty granted, they had actually filed a title suit in Calcutta. That, my lords, upset, my lords, your lordships were very anguished that this, you have already availed of the remedy, the matter is pending, it will be subject to the outcome there. Where is the question of us issuing notice or interfering with an order like this in respect of a resolution plan? That's the reason the matter came up, costs were imposed. Today, the position stands, my lord, subject to your.
Can I be heard?
We can be heard any time, no question of interference. But this is the long and short. There is nothing surviving anymore in the appeal.
And shortcut, my lord. This is shortcut, my issue. But just one. I can remember, my lordship.
We will just adjourn it as it is to another date, and we will hear you on a Tuesday.
It's not right, my lords.
We will hear it. We will give you a date, and nothing will remain in our memories. So you need not worry about it.
Lordships. Well, request to have a short date, my lords.
But fortunately, in infructuous matters, there's no carry forward in
infructuous matters. Well, I'll assess the court orders the matters entirely, my lords, maintainable, my lords, and completely valid. Some early date is the request.
August 19th?
Grateful. It was earlier than that, if convenient to your lordships.
Already have.
February 24.
19.
19. List on.
Can be on the higher
19.
If possible. So that can be.
It's a Tuesday anyhow, so. 19.8. For hearing on admission.
Could it be 1 day
For
here?
hearing on issuance of notices.
Instead of 19th August.
Hearing on issuance of notice.
Instead of 19th August, 1 day here. Just 19th, I have a difficulty. A day after.
It's a Tuesday. We can't take it up on him.
12th or
26th, we've already fixed another matter. Where is everybody going on 19th? The other matter also, we said 19th, the council said no.
This side.
12th or any day, just only. Would be the 20th then.
But I would request for an early.
No, 26, we've already fixed another matter, so it'll have to go to September.
Because I would request for an early date.
Before that, we don't have.
19, my lot, my friends are there. Srinivas is there. My lordship can take it upon that.
These for the RP perhaps. 16th also, we've already got matters. 16th, we've got 2 matters fixed.
The 19th we can.
9th is also not possible.
Hi, my lords. So let us start the matters request, my lords. On our side.
We will leave it to your lordships. Whatever is convenient to my lord.
Then let it be 19th. Try to adjust your work. Mr. Jain, you can appear online also.
Just only one day I have a difficulty. Kindly have it a day here or there. That's all I'm asking. Even earlier is fine. Only that day there's a little. I'm requesting.
No, but if you say no to 19, then we'll have to go to September. We don't have a date earlier than that.
That's documented in January 24. So a day, a week here or there will not make any difference.
Oh, I see. Why don't you finish the other matter and come then? If you have another matter, you need not just limit yourself to one case and one court.
That's right.
That day, we can request.
We'll see. 19th then.
This matter had come before this honorable court on an earlier occasion.
There was a note, a similar SLP.
Page 87, 88.
84.
Was granted. Avoidance application, my lord, we lost up to this honorable court. Page 87, my lord, is the order where this honorable court was pleased to grant liberty. Go back and file an application before, my lord.
Say that the IA is a nullity.
My lord, we say that the
IA filed by the RP is a nullity. After testing the order passed on that IA on merits up to the Supreme Court, after filing a clarification in May, do we need to say anything more, Mr. Ranjan? Delay condoned, we find no good ground and reason to interfere with the interim judgment and order passed by the NCLAT. Is accordingly dismissed.
That's not, sir. To recollect last week when I had, sir.
Yes.
Made a statement that my client was willing to offer 25 lakhs. Lordships are not recorded it because I told my learned friend. Appears there's a huge difference because their demand is far more ahead. So, there are 3 things against me. Just give me 1 minute if I can persuade your lordships. There's a registered agreement in my learned friend colleague's favor, and he has paid 8 lakhs out of that 14 lakhs. Now, my learned friend also indicated since there was a no stay, a sale deed is executed, though possession is not granted. That's a disputed question. Now, only question is whether in the facts of this case, whether your lordships can exercise discretion in my favor to refund the money with interest, whatever rate of interest your lordships consider fit in 3 circumstances. At that point of time, this property is actually one block of houses, though it's partitioned and separate, it's a block of houses. At that point of time, I had purchased this property with my husband at that point of time because she is not educated.
This property fell to the share of D1.
Yes,
in the partition. It was his exclusive property.
Accept all those findings when I go on discretion.
But that was not your case earlier. You said that it was joint property, it could not have been sold by him.
Ultimately, when your lordship sit here after 20 years, agreement of 2005, now we are in 2025, lordship sees the person, the purchaser has a shop in the neighboring property. So the block of houses, this individual part fell to the person concerned. He entered into a registered agreement, accepted 8 lakhs. He is now in Calcutta. After that, my brothers protested that why have you transferred the property to an outsider? So he executed a registered sale deed in my favor way back in 2006. Since then, dispute is going on. 20 years have gone by. The trial court dismissed, appellate court allowed the appeal.
If you're not in a position to settle with him.
Settlement is crores. I can't match that. So the only point I could agree, persuade your lordships to consider
where is the lacuna in the judgment?
On discretion part. Because the discretion part has not been considered.
Take someone who's a third party for a ride and thereafter say we family should retain the house now.
He's not an outsider. He's running a shop.
Very well. Whoever he is, he was brought into the picture by way of a registered agreement of sale. He pays the amount and then you want to revoke it under a letter and on legal notice.
Right.
You don't even take steps to get it cancelled. Straight away, the brother, the D1 executes a sale deed.
Yes. No, lordships are aware of all that.
You can't just do everything you please and then say that it's a family property, therefore we need to.
One can be restitution, my lords, but to tell that.
If you're not in a position to settle with him, Mr. Agarwal, sorry.
Difficult, because the
Then we really find no ground to interfere with this.
discretion, if a lordships can be persuaded to
Sorry.
return the money of 8 lakhs.
We can't allow this kind of exploitation of a third party. This practically amounts to an exploitation. What else is it?
In a way, but it can be compensated, my lords.
Sorry.
My lords, and the property remains.
We find no good ground and reason to interfere with the improved judgment, especially if petition is according to this.
Your Lordship, last date of hearing, your Lordship is directed to take up at 2 p.m.
2 o'clock. We'll take it up.
That's right. That's right.
Now this will take some 5 minutes.
Lordship.
Please.
Yes.
The complainant is my husband's brother. 47.
Yes.
I'm 47.
47.
After losing, I know, my lords, where I'm standing, because after losing in 3 courts, I'm before lords. I have.
You accepted in your cross-examination that you gave the checks also.
My lords, what has in cross-exam in detail, it has come in the evidence cross-examination that he has no low financial capacity to.
No, but you said that I gave the checks.
No, my lords, no.
I court records that you accepted in cross-examination.
Cross-examination also before your lordship. Nothing, nowhere, my lords.
They're not a statement by the High Court to that effect. In the High Court's judgment.
High Court judgment, my lords, probably.
I've noted that you said that you gave the check.
Even I have about 3 to 4 times I have gone through the cross-examination. Nowhere he has admitted. Cross-examination starts from 56. Page 56. Cross-examination.
Para 14. She admitted. 47. She admits that she is a government, also getting it, she not saying. She admits her signature in both the checks. You admitted your signature in both the checks.
The signature, I admit, check belongs to me, not towards the loan amount, my lords. What is
the question.
He was supposed to take loan from bank.
He's your husband's brother, is it? Then
limited submission, my lords. I'm not
you lost throughout.
My lords, check amount is 10 lakhs. Over and above awarded 14 lakhs. 7 lakhs I already paid. Today I will deposit 3 more lakhs. 10 lakhs, my lords, check amount. Either your lordship may consider reducing it to 10 lakhs or limited notice to an extent.
Try to settle it with him if you can.
Sir, 3 lakhs I will deposit today, my lords. Consider record.
How much have you paid?
7 lakhs has been paid.
Issue notice, returnable on 8 September. Learned counsel for the petitioner states that the petitioner has already deposited 7 lakhs and would deposit a further amount of rupees 3 lakhs to prove her bona fides. The amount of 3 lakhs shall be deposited within 2 weeks from today and shall be invested in an interest-bearing fixed deposit with an auto-renewal clause. Interest-bearing fixed deposit in a nationalized bank with an auto-renewal clause. Service shall be effected by all means including this.
Meanwhile, I kindly protect me, lords. I am a government teacher.
What is the stage now?
Sir,
execution.
Anytime they
nothing.
Different order may be stayed. So that
why should we stay the order? No steps have been taken as yet.
As on today, no warrant is.
Then what?
During pending execution, if warrant is.
If there is anything, then you can.
Sorry, my lord, I am not pressing.
Actually, you filed that application at the time of final argument.
Pardon.
Withdraw.
Please. But, I'm not pressing.
Okay. Learned counsel appearing for the both matters.
There are 3 matters.
3 matters. Learned counsel appearing for the petitioner.
The letter, please.
It's that he has instructions not to press these petitions. According to the said statement, the specially petitions are dismissed as not pressed. You have instructions in writing, or tomorrow the party will come with another advocate and say, I never instructed him.
I phoned my friend. Please.
His instructions. This one, actually, he's filed the wrong order. आप जो ऑर्डर फाइल करें ये गलत ऑर्डर है। हमारा ऑर्डर देखिए एक बार। आपने तो कोर्ट ऑर्डर फाइल किया है, कोर्ट ऑर्डर नहीं पूछा था हमने। Which finds mentioned at page 37 of writ petition criminal 251. This is an order passed by the authority concerned. Page 37 of.
Election P16 the same. 37 page पे आपने मांगा था वो that is election P16 clear in such.
इसको समझ में नहीं आता। हाई कोर्ट का ऑर्डर नहीं मांगा था हमने। आप पेज 37 देखिए रिट पिटिशन क्रिमिनल में। Page 37 of the writ petition that you filed, the criminal writ petition, reply dated 25/8/23 filed by the Deputy Commissioner perused, particularly paragraphs 3 and 5 to 7. No further action is required as the main matter is already decided. Vidate order dated 24/8/2018. ये order जो 24/8 जो है वो authority ने पास किया है। आप 24/8 जो आपने फाइल किया है अभी, ये हाई कोर्ट का ऑर्डर है। ये ऑर्डर हमने नहीं मांगा था। ये तो पता नहीं, engage the lawyer and everything is over. पूरा कोशिश करने के बाद ही तो please file one high court order of 24/8.
ये आगे
कौन सा ऑर्डर है?
आज का आपने मांगा था सर रजिस्ट्रेशन में ऑर्डर
कहाँ है? कौन से पेज पर है? नोटेड है पेज, आप नंबर्स नहीं दिए, इंडेक्स नहीं है। एफिडेविट जो फाइल किया है उसका कोई इंडेक्स नहीं है।
यहाँ पे माय नोट और इसका एनेक्चर P16 द सेम ऑर्डर है हाई कोर्ट का 24/8/2028। हाई कोर्ट का ऑर्डर नहीं चाहिए इसमें, तो 24 का जो ऑर्डर आपने फाइल किया है कुछ भी नहीं है उसमें। इसके अलावा तो दूसरा कोई है नहीं। वो डिप्टी कमिश्नर का जो एफिडेविट था उसके हिसाब से चाहिए, वो ऑर्डर चाहिए। ऑर्डर के मुताबिक आप फाइल मैंने कहा था फाइल मंगा लीजिएगा और इसका मैंने एनेक्चर सारे फाइल नंबर जोड़े उसमें सारे डिटेल दिया। सॉरी आप लोग मैंने खबर के लिए भी कहा दिस वेरी 24/8/2018 डिप्टी कमिश्नर क्या हुआ है जो आर्डर का मैंने only this very short and no other order. Deputy Commissioner has कोई आर्डर ही पास नहीं किया इसके अलावा।
इसमें भी ये लिखा ये जो आईए जो फाइल कर रहा है, since the matter is already decided with a order dated 24. ये तो same paragraph जो repeat हुआ है यहाँ। This order is not showing us. He doesn't understand it. आपको समझाने की कोशिश करे भी फायदा कोई नहीं है। पहले राउंड में जो है आपको पूरी तरह से सुन लिया था, मीडिएशन ट्राई किया, सब कुछ हो गया। आप बार बार ऐसे रिट पिटिशंस फाइल करने से कोई फायदा नहीं है। कितने बार फाइल करते रहेंगे आप? एक रिट पिटिशन एक SLP फाइल कर चुके हैं आप, पूरा सुनने के बाद फिर क्लोज कर दिए उसको। Sovereign order, इसमें इंडेक्स नहीं है। 24/8/2018 one small order was there.
डॉक्यूमेंट के कारण जितने आज तक 1/6/2012 से आज तक जितने पूरे ऑर्डर पास किए हैं और डिपार्टमेंट ने पास किए हैं, ऑल आर इंग्रेडिएंट्स ऑफ नॉन कंप्रोमाइज ऑफिसी क्रिमिनल बीच ऑफ द ऑफ देयर पार्ट बीइंग ऑन फेस विल नॉट बी कंडक्ट ऑन हाउस। और मेरी एनेक्चर लगाए इसने सब में साफ गाइड लिखा हुआ है कि आगे करना उन्होंने केवल खतूनी को वो नहीं करे तो उन्होंने रिश्वत ली थी बड़ी भारी 30 करोड़ रुपए की 10 लाख और मैंने रेफर किया Mr. 55 एक आप देख लीजिए कि पहले वेरी क्लियर कहता कि इसमें क्वेश्चन है और हर चैनल को रिक्वेस्ट करता है लोअर चैनल से मैंने
आप ऐसे बोलते जाएंगे तो इससे कोई फायदा नहीं होगा। आप जो ऑर्डर दिखाना था वो ऑर्डर तो नहीं दिखा रहे हैं।
और इसके अलावा
आपका ऑर्डर ये 24 कौन सा पेज पर है? अभी जो एफिडेविट फाइल किया है इनको दिखाना। इसमें आपने इंडेक्स नहीं दिया, कोई डॉक्यूमेंट का कौन से पेज पर है दिखाइए इसमें कहां पर है?
ये तो 30 का
ये आपने फाइल किया है।
ये तो पहले आपका थोड़ा जिसमें आपने हुक्म किया था उसकी बात कर रहा है। अब गलत देख रहे हो।
अच्छा ये
तो पहले का फाइल कराया आपको के बाद देखिए वो हम 16/7 को
ये शायद पुराना है। This is the one which is very good.
और ओरिजिनल रिकॉर्ड में फाइल करते हैं कि
This is not the order.
सर भंडार के
ये जो ऑर्डर आपने फाइल किया है ये कोई क्रिमिनल मैटर में है। क्रिमिनल मैटर में है, इसका जिक्र नहीं किया गया है। पेज 37 जो है वो डिप्टी कमिश्नर ने बोला है कि मैटर सेटल हो गया है, दिस इज द फाइनल ऑर्डर। इसके सिवा वो 24(8) जो ऑर्डर है वो दिखाना चाहिए। आप ये जो ऑर्डर दिखा रहे हैं ये ऑर्डर है, learned counsel for the petitioner submits that as the petitioner has been acquitted by the trial court, this petition has been rendered infructuous. He seeks liberty to file a fresh petition in case the petitioner feels any threat to his life and liberty, dismissed as being rendered infructuous with liberty aforestated. This is not the order which is referred to. This is not the order which is referred to. Sorry, counsel. आपको कई बार सुन चुके हैं, आप सुनते नहीं हैं, आप जिद्दी है। पूरा एलिगेशन होने के बाद आपने फिर कोई फायदा नहीं। The petitioner has filed an affidavit claiming that he has filed therewith the order dated 24/8/2018. However, the order filed by him is an order passed by the High Court of Punjab and Haryana at Chandigarh in CRMM 32466 of 2017, which is in relation to a criminal matter and merely records that as the petitioner had been acquitted by the trial court, the petition was rendered infructuous. This order was obviously not the order that finds mention at page 37 of the writ petition criminal number 251 of 2025, which the paragraph at page 37 is reproduced below. Just pencil se mark. Full stop. The aforestated paragraph reflects that the Deputy Commissioner filed a reply on 25/8/2023 and stated therein that the matter stood decided by the order dated 24/8/2018, and therefore the application filed by the petitioner in CRM 36567 of 2018 did not warrant consideration. Accepting the said statement of the Deputy Commissioner, it appears that CRM 36567 of 2018 was disposed of. The prayers in CRM 36567 of 2018 were multiple prayers were made in CRM 36567 of 2018 and did not pertain to the criminal charges against the petitioner. The aforestated order dated 24/8/2018, which is purported to have decided the matter, has not been produced before this court. In that view of the matter, we are not in a position to entertain these writ petitions. The writ petitions are accordingly dismissed. Dismissed.
My lords, it's already totally illegal matter.
Sorry. Sorry. आप जाइए. Sorry, sorry. उनको ले जाना. Item 50. Item 50. आपको कई बार सुन चुके हैं, अभी नहीं होगा. Sorry. Item 50. आप ले जाइए. ले जाइए उनको. ले जाइए. Sorry. मत जाओ, फिर आप बैठे रहो. आपको कुछ रिलीफ नहीं मिल सकते हैं. Sorry. Item 50. Yes, Mr. Basam. Sorry. कुछ नहीं कर सकते आपके लिए. Yes, Mr. Patil. Yes, Mr. Patil. आप कुछ कर सकते हैं या आपके लिए मदद के लिए किसी को बुलाएं? ले जाओ फिर. सॉरी, कुछ नहीं कर सकते पापा. देखो, ये चौथा केस है आपका, हम सुन चुके हैं. कुछ नहीं कर सकते. आप अपने भाइयों से लड़ना चाहते हैं, मीडिएशन सेटल नहीं कर सकना चाहते हैं, कुछ भी कर. सॉरी. आपको पूरी तरह से सुन चुके हैं. पिछली बार में आपको मौका दिया सही ऑर्डर पर फाइल करने के लिए, आप फाइल नहीं करते हैं. सॉरी. जो ऑर्डर आपसे मांगा था आप नहीं देते हैं, तो उसके सिवा आपका केस डिसाइड नहीं हो सकता. अरे क्या करें. को याद है फर्स्ट कोर्ट में कितने दिन सुने थे इनको. Matter was earlier, 2 matters were heard at length by the Chief Justice. We tried to mediate. Mediation was agreed, and then the compromise was agreed upon by him. Then he backs out. What do? Amicus was appointed. Everything was done. After that, he backs out. The Chief Justice got so annoyed, he dismissed those 2 matters. He's back again with 2 fresh petitions.
And see, in spite of all this, he has not lost his cool. Still the same pitch.
No, but we can understand his anguish, but he has some grievance with his brothers and he doesn't want to settle with them. They were willing to give him property. He agreed, then backs out. And he says, arrest them now in relation to FIR. That is his prayer in the writ petition. So these kind of prayers, he doesn't want a lawyer. We engaged an amicus in the last round. Amicus tried to convince him. She wrote a letter to the Supreme Court saying that in spite of my best efforts, he's not agreeing. Then he attacks her in court. This is an endless... nothing we can do.
My lord, 50.1, I'm making a short request for a short passover. My lords, I've led by Mr. Dhruv Mehta. He's on his 16.
I'm in 50.
2003 acquisition.
But the
Same one, na? 50.
I'll just give the few statistics, my lords, which will shock my lords.
Anyhow, we'll pass it over then the other.
On Friday, my lords, instead of passover.
Very good. List on Friday.
This much, my lords.
Please just quote, lords.
Yes.
Completely erroneous reading of 53, lords. Plus 53 directly says those constructions which proceeded under 52(1)(a) without permission.
High Court on its own motion order is extracted and relied upon.
That, lords,
there is a question of you saying that I won't even secure a permission.
started, I have already applied.
After you construct it. So everybody can just construct and then
Go for regularization.
That is why that High Court on its own motion order explains what this provision is for.
Admitted the SLP against that clause. Your lordships have also granted an interim order because it's the face of a Supreme Court judgment. There are 6
Is that you can make illegal constructions and then seek regularization? Which judgment said that, Mr. Parameshwar?
It doesn't say that. Right?
Then
Apply within the regularization period and it gets regularized.
After constructing,
After constructing.
without any permission.
where is the question? This kind of illegality has to stop somehow.
Question of illegality.
It is an illegal construction. Where is the question of you just saying, I have land, therefore I will construct, thereafter I will apply for regularization?
For a minute. For a minute. Because on this very point, Mulat's own motion is admitted in this court, Mulat's. There is an interim order in favor of the person who has come against that judgment. So far as 53, may I just pass on the act to your lordship, Mulat's?
Let the building go, the matter can be decided. There's the question. You can't say, I won't even take permission, I'll build an illegal building and thereafter seek.
The lordships notice two dates, Mulat's. Our application for regularization.
Do we even know whether your construction is in accordance with the permission, the acts?
Under 53 is pending.
Where is the question? You can't. Where is the evidence of your construction being in accordance with the required norms? Where?
I should just note 3 dates, Mulat's. He loses the High Court writ petition on 8/10/2024. This is a disgruntled neighbor who's at me, Mulat's.
Well, every neighbor is entitled to protest against the illegal construction being made in his vicinity.
He wanted the plot for himself. He goes right up to the High Court, loses that, Mulat's, then files a writ petition. My application is.
Well, you opened up yourself for the attack by making an illegal construction without any permission.
Dates, Mulat's. 29/11/24 is my application for regularization. The first notice stating that this is an illegal construction comes to me on 21st February 2025. Now kindly see 52 and 53. It is on this very question on own motion is now admitted before your lordships, Mulat's. Pending resolution. This is the only judgment. There are four division bench judgments of the Bombay High Court which say even if you started construction without permission within the 30 days, if regularization is permissible, if
this kind of activity we should not be condoning.
Lordships have admitted in the judge. SLP
Anyway, we'll just tag it along with that. We are not going to grant any relief. Let this illegal construction go.
Kindly have a look at the order which is passed in that.
Where is that order?
Just passing this.
Legal construction?
No.
But there are 4 judgments of the Bombay High Court, Mulat's, which
That you construct the building, then apply for.
Kindly see, Mulat's.
Yes.
It's time for vacating is so and so. The petitioner herein to vacate the said premises so and so.
You're supposed to vacate.
However, there shall be a stay of demolition of the buildings till the next day.
To enable you to vacate.
In that case, he was a tenant. However, there shall be a stay of demolition of the buildings till the next day.
But from this order, we cannot arrive at a conclusion that there was some building permission, some kind of building permission.
Second, the same suo motu order.
No.
Demonstrate that. Lordships, kindly see, because there's a 3-floor building that is going to be pulled down. At least one right of appeal.
That's the question. You open yourself up for this kind of coercive action when you make a building of 3 floors without even applying for permission.
That is, would your lordship see section 53 for a minute? This is my first appeal again.
Sorry.
It's found the building illegal construction while my application.
There's no found me is not the issue. Admittedly, it is an illegal construction. There's no question of qualifying it.
The compounding is there in case you deviate from the building plan.
Say, kindly see 53 for
It is not for those cases where there's no permission at all and you've constructed a building.
Because the orders.
Which is exactly what the High Court on its own motion order says. That if you had a permission and then there's some irregularity, then you can at least go there.
Your lordships, kindly see 52, 53 for a minute plus. Because this is the first time that the High Court has asked me to pull down a 3-floor building. Would your lordship just give me the
52 or 53?
Millards first. 52 Millards first.
Yes.
Any person who, whether at his own instance or at the instance of any other person, commences, undertakes or carries out development or institutes or changes the use of any land, your lordships will mark A, Millards. Without permission required under this act, shall on conviction be punished so and so.
Well,
I am covered under A because I undertook the development, Millards, without permission at all.
Doesn't mean that you go to prison and save the building.
see 53 now.
Yes.
Can I only request 53? Where any development of land has been carried out as indicated in subsection 1 of 52, the planning authority may, subject to the provisions of this section, within 3 years of such development, serve on the owner a notice requiring him within such period, being not less than 1 month, as may be specified therein after the service of the notice.
Where are you reading?
53, my lords.
1.
Yes, my lords. Where any development of land has been carried out as indicated in the subsection 1 of 52, the planning authority may, subject to the provisions of this section, within 3 years of such development.
No. 53 says serve on the owner or occupier prior notice of 24 hours.
No, that's I think this is the amended, the pre-amended version is this. I'm assuming it is. I've just circulated that.
When was the amendment? Amendment was in 2017.
Would your lordship?
When was this litigation started?
24 minutes.
So this amended provision would apply.
24 minutes. I have no problem. Let's serve on the owner a notice requiring him within such period, not less than 1 month, as may be specified therein after the notice of the notice, to take such steps as may.
No, there's separate provisions here. This is what the High Court on its own motion order refers to. If it is a violation falling in A or C, 24 hours. If it is in B or D, then you get 1 month.
If it is 24
24 hours, if it is completely without permission, you need to restore it to its original position.
My apologies, I didn't finish reading clause A.
No, but you're reading some other provision. This is not how it's.
But we'll find it at page 11. The impugned judgment specific.
May I just.
It refers to that,
Yes.
but the provision is not extracted, perhaps. We've read the order.
Would your lordships kindly see clause A? In cases specified under clause A or clause C of.
Let me see this provision, what you have extracted, how it is different. 53. This is obviously the unamended provision. What you're reading out, which is not what is applicable as on date.
Even in the amended provision, kindly see the curability. Even in the amendment, I'm saying, assume for a minute, kindly see A. In cases specified in clause A or C of subsection 1 of section 52 to restore the land to its condition existing before the said development took place. Now see clause 3. Completely unnoticed by this division bench. Any person aggrieved by such notice may, within the period specified in the notice and in the manner.
This is in relation to 1A and 2, not 1.
1A.
B and D situations are different.
This is 3.
C and D is what is applicable for this 1 month notice and this 3, not for 1.
Any person aggrieved by such notice may.
Aggrieved by such notice refers to what followed after 1. That is 1A,
It's different.
1A and then 2.
3 is not only restricted.
3 isn't, that is how it has to be read. Once 24 hours notice is to be given to restore, you can't extract 3 and say it's to be extended to 1 also.
Just kindly see 3 for
That other case which you're referring to seems to be entirely different. Some tenant saying something. That may be so, but this case stands on a different footing. Sorry, we're dismissing your matter. We find no good ground and reason to interfere with the impugned judgment, especially a petition accordingly dismissed.
There are 2 paragraphs, certain uncharitable remarks against the counsel who argue that. Okay, let's kindly see that for a minute.
Which paragraphs?
My apologies, just a minute.
Which paragraph?
18 minutes.
Para 18.
3 lines.
No, but this kind of argument before the bench, obviously the bench was constrained to make a comment. Persisted in relying upon judgments that are inapplicable. He further insisted that this court's understanding was erroneous, while his submissions are and were the only correct ones. He makes those kind of mess the matter. We do not know in what language he put it.
Your Lordship, kindly come to your Lordship's order dated 27/9/2024. 27/9/2024, your Lordship's order.
Yes, yes.
Yeah. Lordship, kindly.
Or perhaps the other side has entered appearance.
File my counter affidavit, pay for the complainant and also for the victim. There was as many as 42 cases registered against him.
In this case, he was granted anticipatory bail without conditions. There is a question. Merely because the charge sheet is filed.
Has my counter affidavit.
And we'll take it up for hearing on another day then.
In fact,
If you wish to have a hearing on that, then we'll take it up on a Tuesday.
Your Lordship, the directive was by the order, VD which your Lordship had issued notice for him to appear before the court. Despite the order clause, he's not appearing before the court.
No, we have been appearing, my Lord.
I have produced the court clause, the docket orders of the court. It said
My
that
Lord,
he's
he
not
appeared. Your Lordship, kindly consider he was in
10 dates he's not appeared.
He was an inpatient at Apollo Hospital. Therefore, he engaged the counsel. Counsel filed a petition at 317 along with the medical record. Presence was.
No, but 10 times he didn't appear.
10 times he did not appear. I have placed on
Is
record.
that so, Ms. Nagmatu?
He was in Apollo Hospital. He engaged the counsel. The counsel filed a petition.
He continued to remain in the hospital for 10 hearings.
What is the documents?
I have placed on record the docket orders also.
Well, anyhow, you have ample time now to file a rejoinder if you wish to. File a rejoinder then if you need to place any documents. Rejoinder is also filed. You filed any document to support this then?
Yes,
None.
No document.
Before the next hearing date, we will file.
We'll take it up on, I see it can't come on now.
Tata, 10 cases, 300.
Can it come up on a Thursday? Criminal matter, no? No? Won't come. Won't come up maybe. It can come up. Then 31st. 31st July.
Lord, may kindly permit us to put the additional documents.
Additional documents, if any, may also be filed in the
What I
meanwhile.
would like to submit, Murad. Every time Murad to
But interim order,
Murad, he appeared through the lawyer. He filed a petition under section 317. It was allowed because there was justification. Murad, it was allowed by the London magistrate.
Bless my lords.
Second of August.
First
Week of August. You can. Week of August. First week of August.
Well, maybe during.
sorry?
Maybe during second week of August.
Oh, you don't want 31st. Mr. Divyesh has gone.
I will inform him.
Oh, yeah. He wants another date, not 31st. When?
Second week, any time.
Second week of August. Second week of August may be difficult. 12th August. Very well. 12th August.
Great. Very good.
Grateful.
It's after this matter, my lord. She is a
Preventive detention period must be over by now.
He's absconding.
Preventive detention was not effected.
No, I am not absconding, my lord. I am there.
Order was passed in 24th November.
27 November 24. It's not been implemented.
My lord, I am participating. I am, my lordship, very much.
But it's a preventive detention order. What do you mean you're participating?
They are the antecedent and there is the other trial pending.
Preventive detention order. It's not an investigation that you're participating in.
Pending, my lord, I am.
No, but preventive detention.
Not taking any action. I am very much there, my lord.
She's absconding.
According to him, she's absconding. File a counter then.
They have already filed.
File a counter. We don't have a counter.
They have not mentioned in the counter that I am absconding.
Sorry?
That is not on the record.
Counter has not been filed as what the office report says.
Saturday, on 19th.
19th. This is 19th only. Very well. You've received a copy of the counter. Wherein they've said that you're absconding.
They have not said that I'm absconding. They have not said anything about it.
What have you said in your counter then?
This was all my
counter. You have an extra copy? No, just to know what you said. Otherwise, read out the relevant portion. He says that you've not mentioned that she's absconding.
You don't
not
have
said that.
You don't have the counter.
We haven't mentioned.
That's what I'm saying.
You didn't say that she's absconding. What did you say about implementation of the order then?
So I file a better counter.
Then on what basis are you saying that she's absconding now? If the counter is silent, why did you say she's absconding then? I told you orally, after the counter was filed. What is the meaning of that?
My sincere apologies for that.
And my lordship, please see, there is two antecedent in.
When this order would have worked itself out if it's so for 6 months.
I am not taking any action. I am not running away, my lordship, because I am already facing a trial wherein I am appealing through my lawyers. I have to participate.
How does this order read? It says 6 months from the date of detention, or? Normally, from the date of the order, it would be 6 months. Then that period is over unless you've extended it. Have you extended it?
No, 32. No, they haven't extended, my lord.
It remains then.
If you see the other background, there are only two antecedents, and in one antecedent, I have already completed the sentence of the 2 months because like the very quantity was around 20 grams. The other antecedent, the quantity was around
the PIT and NDPS Act.
72 kg.
How does the Act read with regard to the period and the extension? You have the Act with you?
Lord, I have
PIT and NDPS.
Lord, I have not examined that part actually.
Not the NDPS, PIT and NDPS. Is it there in this?
Yes.
88 Act. Not there. इसमें नहीं है. अलग एक्ट है. Preventive detention. 1988 का एक्ट है.
Only on the basis of two independent witnesses, they have actually passed the order, my lord.
The order might have worked itself out. You examine that aspect also. We'll need to see what they said in the counter. He wants to file a better counter without us seeing the first counter itself. In the meanwhile, you examine this aspect also, whether this order even survives for consideration. We'll take it up next Monday. Based on next Monday's date.
Lord, wait on Friday.
Next Monday is 20.
DPO available.
Service is incomplete because you did not file spare copies or pay the process fee. You're for the petitioner, counsel. Counsel. Hang ho gaya. Hang ho gaya.
My lord, kindly grant me one day, my lord, and I will file the process.
Counsel for the petitioner.
Please, your
take necessary steps for effecting service of notice on
hiring, my lord. I am for the petitions, my lord.
Needful shall be done without fail. अभी justice Roy का judgment आ गया ना, तो उसके हिसाब से insurance. He said that light motor vehicle license, you can drive a transport vehicle of up to 7,500 kg. 7,250 kg से ये 250 kg से बच गया. List on 1st September.
Please, your lordship.
Yes.
Like to appear for the petitioner state.
What happened to that pending matter? Connected matter was there?
Well,
sub enterprises.
So I think has been disposed of.
It's been disposed of.
Disposed of. There, the High Court had condoned. That was a
matter pending before this court. On the last occasion, the office report mentioned so.
It was
before Justice Abhay Oak's bench.
as well as that has been disposed of.
It's been disposed of. Can you show us a copy of the order? But that might have some impact on this matter. This is especially appeal C number 241. 21111.
The order is at page R11. It's an extra P11.
You filed a copy of the Supreme Court's judgment. This matter was pending as on 17/9. Notice was issued.
of the counter.
The counter.
One.
That particular case, the delay was condoned.
Delay was condoned. Orse brothers. Then 75 days delay. There's a question of non-suiting him on the ground of delay then.
He remained pending for 11 years.
As per the last order, they were directed to actually deposit the entire amount.
They've deposited.
The amount itself is more than 2 crores. They have deposited 1.66.
Two was deposited earlier.
They could just file some statement because this is award was past 2 decades back. In fact, in the claimant company itself, people have moved on. So
1 crore 66 lakh 80,491 was deposited pursuant to our earlier order.
The principal amount itself is more than 2 crores.
The principal amount is 3.66 crores. Earlier, when they had filed an enforcement proceedings, I was directed to deposit 2 crores, which I had done. The balance 1.66 crores has been deposited on Lord's order. So it's 3.66.
That's on that. What I'm told, of course, my client people have moved on and there's only so much documents that they have. What they told me, Lords, that apparently that amount of 2 crores which was deposited in the execution court was withdrawn by them. They had filed some application and they had...
In any event, the 37 appeal can go on now. This, in the light of Orse brothers, 75 days delay can't be held against him.
So one submission on that, if your lordships may have para 40 of the impugned order, the grounds on which they had sought to condone the delay, they are only government delays and file pushing, as Orse brothers says.
75 days is still just 75 days.
But I'll leave it to your lordship. I'll leave it to your lordship.
I will in the light of this specially petition arises out of the judgment and order dated 22/12/2023 passed by the High Court of Orissa at Cuttack, non-suiting the leave granted. The appellant on the ground of non-suiting the appellant in an appeal filed under Section 37 of the Arbitration and Conciliation Act 1996 on the ground of delay of 75 days. According to the High Court, this delay has not been condoned. Para
65 of the High Court, it says it's not condonable.
Page
28, my lords.
Oh, looking at the
impugned order.
One moment.
The High Court relies on both.
50? ये कौन सा volume है?
Page 28, para
Right paper book. It's okay.
This one. But it starts at page 55. No.
Para 65 minutes.
65. What did I say? As it was beyond the limitation period. This understanding of the High Court is clearly opposed to the law laid down by this court in Government of Maharashtra, within brackets Water Resources Department versus Messrs. Orse Brothers, Engineers and Contractors Private Limited, 2021, 6 SSC 460. In that view of the matter, the appeal is allowed, condoning the delay of 75 days in the filing of the appeal by the appellant under Section 37 of the Act. The appeal is restored to the file of the High Court for adjudication on merits and in accordance with law.
One indulgence, the award is of 2005, 2 decades have gone by.
The High Court shall endeavor to dispose of the matter as expeditiously as possible.
Grateful.
Deeply obliged.
Item number 56.
I'm just going to pass my lordship.
Would your lordship hear it on a non-miscellaneous?
What is there to hear in this?
My lord, I don't.
Where is the question? Paso.
So I am appealing for the respondent now saying 8408 of.
नहीं, dismiss तो नहीं हुआ.
No. Pending.
Yes.
I filed my counter and replied to the condonation. I am seriously objecting to the delay of 458 days. Filing the SLP.
Other connected matters, and this also we have not yet been served with this one.
I have one more.
Otherwise, this matter is already your lordship been covered by your lordship's judgment only with regard.
Which one?
28. This one only.
It's covered by which judgment?
Justice Chandrachud's judgment, your lordships, in synopsis itself,
Section 28(9) is considered.
has been decided by the review petition.
What is it? What does that judgment hold? Have you seen that judgment? I'm not aware of this judgment.
I will tell Malas.
So let us see that judgment also. Where is it? Is it a reported judgment?
Now it will hold, your lordship.
It is a citation.
CA number, review petition was there, lordship.
You said it's a reported judgment. Give us the citation.
Plus, Canon India is with respect to the powers of the.
We'll have to see the judgment before you start distinguishing it on facts.
Review petition is there, lordship, 400.
Is it a reported judgment or is it not?
It is, I'll just.
The reported judgment, you should have the citation. If you don't have the citation, file a copy of the judgment then.
If I can take 10 seconds. Malas.
You are aware of the judgment. Is it reported? Is it reported?
Reported judgment.
Then somebody give us a citation then.
But that is not.
How is it that you are ready to distinguish that case on facts without even knowing what the citation is?
10 seconds. Right at the moment, Malas, my screen is. If I may just give brief background of the judgment.
There's no need. We have to hear him first. In any event.
Please file a copy. Let us.
Learn counsel for the petitioner. As
We are not
the
deciding.
matter is squarely covered by an earlier judgment of this court. He says time to place on record a copy thereof. We'll take it up next Monday.
One more submission I want to make, Malas. Just give me a second.
After we hear the other side.
Something on record. That's why.
What is that?
The High Court undertakes a detailed fact-finding exercise based on the record that he produces before the High Court and comes to a factual finding. In the SLP, Malas, that record has not been placed. Now, Malas, whenever he would argue, I would want to show that the judgment was reserved thrice and the order was not passed, and that's why the High Court came to the conclusion which it came to. Now, that's not the part of the record, Malas, so far as the SLP.
Whatever record was placed before the High Court, please show it to us.
Will do.
Counsel for the petitioner shall also place before us the record that was produced before the High Court at the time of adjudication.
7.1, 2 and 3 lordship I have written.
Sorry?
7.1, 2 and 3 lordship. In 3 lordship, the litigation, it's hit by litigation policy. It is tax liabilities below 2 crores.
Have you filed your counter there?
I will file.
File your counters. You have a week's time now. Yes.
I have deposited amount as per the direction of this court.
Very good. Other side is appearing.
Seeking 4 weeks time to file a counter.
File a counter. Very good. And counsel appearing for the respondent seeks 4 weeks time to file a counter affidavit. Public reply. Rejoinder thereto, if any, may be filed before the next date of hearing. List on 22nd September.
Obligement.
59 as
Service is incomplete.
the counter affidavit, it's not.
You are appearing for R1. R2 and 3 are not served.
Parties, formal parties.
Oh, GMR also, is it?
No, it's not.
No, it's not there.
For your information.
3 weeks time.
R2 and 3 are not served.
What parties minutes?
But you have to take steps then.
Respondent.
And counsel appearing for the petitioner seeks some time to take necessary steps in relation to unserved respondent numbers 2 and 3.
There was a connected.
Strong.
We tagged before, man. What happened was there were two
That's
assets.
another matter.
Not here, it was in court number 17. It has been directed to be placed along with typing.
This is it. That's been tagged with this.
So both the common
Common
Right.
order. Let's,
John, how much time do you require?
it's time for rejoined at 2 months. Counter we are using.
15 September. Yes. 61.
This was ordered to be relisted for today, my lord.
Cryptocurrency.
Case lordship, it is for anticipatory bail on 2 grounds.
Yes, नहीं
बहुत सारा compromise किया है।
evidence कहते हैं लेकिन क्या है sufficient evidence नहीं बताते.
और काफी लोगों से compromise भी किया है। Yeah.
They have sufficient evidence against him. And what is the sufficient evidence?
And mediation में इतने मार गया है उसको पढ़ा नहीं किया है. Issue notice तो again ही हुआ.
NDPS का case है.
And no.
Where's the NDPS?
No, cryptocurrency.
Which one are you looking at? 61.
This is
61.
Last में notice कर दिया.
Notice नहीं किया. We kept it for today.
We will do it.
We'll issue notice, Mr. Sangwa.
Please, my lord.
Why was it adjourned? In fact,
My lord observed that some.
why?
Because I'll tell you. No, because I said there are 4 cases against him.
You have 4 cases against you, but what is your link to this case is the issue. Issue notice, returnable on.
Lord, can I pay for interim?
Not at this stage. Let the other side come. 25th August. Service shall be effected by all modes.
This is cryptocurrency.
This is a cryptocurrency.
Wait, please.
This is a cryptocurrency.
With the utmost respect, mediation says
Mr. Agarwal, he's out on interim bail on the ground that he's going to settle.
And he's not.
And he settles only with some 28, is it? 60? 24.
it is the documented position.
1 victims, 38 victims say there's no settlement.
May I just indicate?
Part settlement.
Please just have with me the 3 settlement agreements. I think that's what has happened.
But we have this many number of people. You settle with some of them, but what about the others? And you take advantage of this interim bail, remain outside, but you don't settle with everybody.
Judgment reads, and I have no doubt about it. But I want your lordships to look at 3 pages with me, because what the Honorable High Court says that the mediation, the mediator has not ensured that the mediation has worked itself out. He has only recorded a commitment to do so. Please just have the settlement. First one, page 124.
This is with how many people?
There are 22 persons. This is the mediation center, which is an extremely structured mechanism in the Delhi High Court. Please come to 127, para 1. Second party agrees that in full and final settlement of their respective claims against the accused persons, they have received.
This is the 23 people.
Please just give me one moment.
One more also you seem to have settled with.
Please also.
If you look at the figures, 61 victims, 38 victims not settled. So you obviously settled with 23.
I will demonstrate more. Please come to page 131 as well, where not only is it signed by clients, it is signed by their respective counsel.
Very well, this is the 22 people there. Then
please come to the second settlement, page 149. This is now with additional 13 persons.
Where is the recital that you paid the entire amount?
Mobilized bloods, please come to 152. Para 1.
Yes.
Third line, have received.
There, 152.
52, the last paragraph, not paragraph 1. Number.
Received.
Second party agrees that in full and final there is.
Have received. Names are there, council signatures are there, your lordships.
13, 22 plus 13.
13.
That's
11. 11, no?
No.
13? 30.
13, 22 plus 13.
So 35.
This is recorded by the Honorable High Court at page 157 in an order sheet.
Very well, that takes up the total to 35.
Please then come to page 163.
160?
63.
Yes.
13 more persons.
12. 12 more persons.
Sorry.
Right, your lordships are right. I'm sorry.
Where does it record the payment?
Please come to paragraph 1 pertains to the first person who was there in the first settlement. He had not encashed his 4 lakh check. So he says he's a party to the first settlement.
Oh, they've only received checks, is it?
Some persons received.
So in all probability, those checks might have bounced. How do we know?
Encashed, except
You can't bind them with just these agreements there.
one person at para 1.
No, but we will have to take your word for it. That's all.
The submission, and that's a
We know.
check is a demonstrable position. I have given a check. The check number is there.
Not settled then. The whole point of your being set free on interim bail was to settle.
All of them are in cash.
And this judge records now that in spite of several predecessors granting you time again and again, you've done nothing.
And may I just indicate that? Please come to 169. Specific check numbers for these 6 persons. And then paragraph 4, various other persons acknowledging receipt of the specific amounts in cash.
So even then it comes to 47.
Please
then
have the
14 more still remain.
page 176. Because what has happened subsequently is that all these persons now go and say, no, I want more. After actually entering into these mediation settlements, their counsels signing, them signing, they now go and say.
But we don't know what happened with these checks, whether they're saying that the checks are bounced. The order records that you directly deposited 1 lakh in 2 people's accounts without their knowledge.
Hey, bow down, I'm submitting.
Some you're depositing in the account, some you're paying checks
Any
by way of checks.
Any person who has signed these settlements, counsel has signed, at least they are bound. At least they are bound.
But even then the figures still don't add up. You've got 2 more people here. So that's 49. That's 2 more people.
And then subsequently, 19th of July, page 183, another 1 person. And finally, 8th April,
50.
And page 201.
Yes.
Please have page 202.
But what is the point of?
My submission is this.
Just an abuse.
All of these.
You settle it with everybody.
There's
no question of giving you bail again and again and again and again.
Ask myself one thing. If I am able to successfully settle everybody, the outcome is going to be a quashing of the proceedings because that is what is agreed. Today, I have demonstrated not only the fact that I have spent 1 year, 10 months in custody, charge sheet stands filed, charges have not been framed. I am a person who's 65 years of age with medical ailments, but I am also a person who in this interregnum has settled a significant majority.
Yeah.
And please just.
We won't grant you any interim relief now. We'll issue notice on.
Because I was on interim bail, I have
committed to surrender. You surrender now. You surrender now.
Angioplasty.
This point of time, no interim relief. You surrender.
Undergone. I'm in the hospital.
Angioplasty doesn't require such extensive medical treatment that you need to go to a
may I then request
5-star hospital now.
May I request one thing? Given that he's in the hospital, if your lordships grant me time for
in the hospital right now, where is the document to prove it? You should have filed it along with the SL.
In the additional documents.
We don't have any additional documents here.
Right? I'm sorry, he's in the hospital.
So there is
with us.
There is an IA. You filed it along with the IA.
Not the medical documents. I've told them get it. Please take it. He is in the hospital. He's
some private hospital which conveniently gives you a document.
He's undergone an angioplasty. Stents have been placed. But that is something, which I can't. Please take it. We'll respond.
What is the document?
200. Specific thing on the current thing is 204.
When was he admitted?
04, he was admitted on 16th of July.
The date of admission is 8th of July, 2025.
That's a prior admission, 8th of July. He was
then he was discharged.
He was discharged at 204. My instructions are he was admitted on 16th of July. He has undergone this angioplasty. He is currently in.
Where do you find this admission on 16th July? There's no mention of anything.
Have 207, 206, 207. It's been drawn. The specific biological samples, etc., have been taken on 16th, etc. He's an inpatient.
Just where does it say that he is an inpatient?
PID, inpatient identification, patient ID.
And where does it say that he's undergone any procedure?
Because I take it what your lordships are taking to me.
You go before the High Court and seek extension of time if you have. We are not going to grant you.
Please record my statement below that he's under.
At this stage, nothing. We'll just order notice. Beyond that, any further relief, you go before the High Court.
Your lordships is observed.
So notice returnable on
liberty to seek extension before the High Court.
We won't say anything. If there is a direction to surrender within 1 week or something like that. If you're unable to comply with that and you have reasonable grounds to make such a relief, such a prayer, you go before the High Court and ask for extension.
Dismiss the petition.
The petition is dismissed. If you have good grounds to ask for extension of time. The High Court has nothing against you personally that they will say that we won't grant you extension even if you're in the hospital.
What happened is the Honorable Court says,
The High Court, please.
after 1.5 years of interim bail, I was.
Mr. Siddharth, we are not going to grant you any relief at this stage. Issue notice, returnable. Date दिया है?
I'm obliged.
Please, my lord.
This
Fuel charges.
This perhaps requires a hearing. It's also very technical, so we'll have to hear you.
The Lotus permit.
We'll take it up on a Tuesday, perhaps.
A small 2 or 3 page note to be handed.
Yes.
Fresh matter which is coming up today for the.
No doubt, but this requires, because we already have too many matters to be heard in the afternoon also.
Bring to my notice something. This is with regard to surcharge, which is till the period 2000.
Fuel surcharge.
Surcharge is now built into the tariff. Number
I
2
see.
is Honorable High Court is appointed, has already done 7 hearings. We are at the fag end.
Very.
My lords, at this stage, if my lords were to consider interfering.
We are not saying anything at this point of time.
Yes, because this is what I wanted to bring.
No order at this stage. We're just adjourning it to hear it on another day at length. We're not granting any order.
This will consider.
We are not granting you any order at this stage. We've not even gone through the whole thing because it sounds very highly technical.
Calculation. So he has to decide.
Just one more. One more minute, my lords. The Honorable Patna High Court had initially passed an order, issued certain directions how you will calculate this surcharge.
Right.
That matter traveled to this court. This Honorable Court affirmed that order. Now, my lords, the division bench in the present decision has said that you have not followed the directions of the Patna High Court. Therefore, we are appointing a committee. So, my lords, my respectful submission is, if they are aggrieved by the committee's observations, they can go back to the High Court, my lords, because this Honorable Court will, for the first time, require.
At this stage, we are not going to say anything at all.
The single judge holds in my favor.
One way or the other, we are not saying anything at this stage.
May I only make a small suggestion for your lordship?
No suggestions also.
I will hand up the note, or file the note, 2-page note.
We'll take it up on. This can only come on a Tuesday meeting. It also. Eighth 8th August. 8th August. It's a Friday, but we'll take it up in the afternoon.
Would your lordships consider, if it meets with your lordships?
Notes not exceeding 3 pages may be filed by both sides.
Meets with your lordships. Could your lordships just say that the committee is not?
We are not saying anything at all. We have not issued notice also. Where's the question?
It's an order saying fix on 8th, the proceedings will get stalled on ground. So let them.
We clarified that the pendency of the special leave petition will not preclude any authority from proceeding with the hearing of any matter pending before it.
But it not be given effect to. So, did you with the passive?
You want an interim order? So, we'll continue. Oh, sorry. We can't. We are not granting any interim order. No order at this stage. Beyond the scope of this case, if you're asking us to stay the.
Single judge is entirely in my favor.
We'll see. We'll hear you on that day. We'll continue with the list and then take the passovers.
There is an express prohibition under Section 8, the Commercial Codes Act, against
Commercial Codes Act.
Extracted it in page 37A. 37A. There is a decision of Telangana High Court and Delhi High Court in my favor. 37A, my lord. Bar against revision application or petition against an interlocutory order. Notwithstanding anything contained in any other law for the time being in force, no civil revision application or petition shall be entertained against interlocutory order of a commercial court, including an order on the issue of jurisdiction.
Not applied to 227 though.
That is the decision, my lord, which I have passed on.
Where is the decision?
That last time it was.
We don't have anything.
After
you did? I've got to have one.
I will pass on my copy, my lord.
Not there.
I will pass on my copy. Yes. Last time.
This Telangana High.
Telangana High Court as well as Delhi High Court.
It's to Delhi High Court.
Lord, in Telangana High Court, my lord, Lordship may pardon me for highlighting this, because para 12, my lord, in Telangana High Court. The bar contained in Section 8 has been revisited by High Courts from time to time. In M.V. Ramana Rao, a division bench of this court construed the bar as being restricted only to a revision under Article Section 115 of the CPC and not affecting the power of judicial review under Article 226 and 227 of the Constitution of India. This view was reiterated in Harpreet Singh Chabra. M.V. Ramana Rao, however, sounded a caution in invoking Article 227 of the Constitution.
Only sounded a caution, not that it.
Further, I will read. For the sole purpose of circumventing Section 8 of the 2015 Act with reference to the self-imposed restriction, it is settled on that the power of superintendence of a High Court under Article 227 is not an unfettered jurisdiction where each and every order can be corrected or interfered with, apart from the broad outlines of flagrant abuse, miscarriage of justice or dereliction of duty. The High Court must be conscious of invoking the power within limits. The limitation to such power would particularly assume importance in the face of special statute like the Commercial Codes Act 2015, which was enacted for the specific purpose of speedy resolution. My lord, then towards the end, my lord, we are paragraph 17. We are therefore of the firm view that the bar contained in Section 8 of the 2015 Act would fully apply to the facts of the present.
On the facts of that case. There's no principle laid down that no 227 petition would lie.
As deprecated. Here,
deprecating is one thing, but on a case on facts, if interference is warranted, the High Court is entitled to exercise 227.
W's 1 to 3 examined.
The court says, thus we hold that the petition under Article 227 of the Constitution of India to be maintainable.
And only under
indeed lie against such an order.
Against under extraordinary circumstances.
But that is for the High Court to decide.
As far as this case is concerned, my lord, PWs 1 to 3 were examined, DW 1 was examined. Thereafter, an application was filed to recall the witness. My lord, and that application was partly allowed. 2 other applications were dismissed. High Court by a 25 pages order.
You are required to produce documents.
Wanted this application, my lord.
What is the difficulty in your producing those documents? If you are running a legal establishment, then you should not be fighting shy of it.
Mercil Court is the best judge to decide which application to be allowed, which document to be produced, who has to be re-examined.
Learned judge has passed a detailed order.
High Court cannot interfere, my lord.
Where is the question?
At this stage, my
You
lord.
can't draw those kind of
My lord,
bracketed barricades now.
what cannot be done directly cannot be done.
No. 227 power cannot be equated with 115 CTC.
That's what the 2 high courts, my lord.
They have not said that 227 shall not be exercised.
As far as this case is concerned, my lord,
They have not said so in this judgment. So why you are saying that?
Some case is concerned.
Dismiss it.
Sorry, Mr. Chidamrish.
My lord,
you cannot entertain.
May make one submission, my lord. My lord, now that there is a remand, my lord, shall be considered untrammeled by anything observed here. Because
where are the observations on merits anyway?
On merits, there is much observation.
That is where do you find any observations on merit?
90, page 19 and 20.
Page 19?
20.
Yes. Needs to be examined.
Paragraph.
Availed alone, it is an admitted fact.
Kindly see paragraph 28.
28.
To ascertain such official facts, an officer need to be examined. That is the first witness who is the authorized officer under section 244. Maintained. Those are the documents ought to be called for. Then paragraph 29.
Only the documents that require to be looked into. There's an expression of opinion on the merits.
Official documents, paragraph 29. Those factors were not properly considered and evaluated by the trial.
There's nothing in this, Mr. Chidamrish.
Not anything, untrammeled by,
We find no good ground and reason to interfere with the impugned judgment and order. The specially petition is accordingly dismissed. Nothing. Yes. This is also case for dismissal.
Yeah, how would it be done?
Foreign
minister and foreign to the family. तो बच्चे भी नहीं हैं.
It's a critical license, which was.
Today is not your day, perhaps. Today is not your day, perhaps.
Every day. At least speaking for myself, I don't know.
15 years delay. Where is it? The first transfer took place when 89. Then you wake up in 2005, 4 or 5, with the backing of a MLA. Then the minister holds in, one minister held against you, then you go back. Then minister holds in your favor.
The collector held in my favor way back in 2008. Then Milos commissioner holds in my favor.
That's because of all the political string pulling that is going on.
Petitions are very easy to make if the minister was in.
Fact remains that for 15 years, there were transfers of license going on and you kept quiet.
Right.
15 years later, you wake up, there's not even any evidence of you being the daughter of that initial person.
There is
the license holder. Well, we don't know. Even that, even if you are the daughter, if you are able to prove it, daughter or daughter-in-law, whatever you are, 15 years delay is enough to seal your fate.
I understand.
There's no question.
Continuing wrong, Milos, if suppose some.
No question.
License.
You just wake up and now you want that license. No good ground and reason to interfere with the impugned judgment passed by the people, especially petitions accordingly dismissed.
Right.
Yes. You lose the records and then you want to. Are you aggrieved by the direction to reallocate, or are you aggrieved by the 2 lakh compensation?
Manox will see.
Seriously.
28 for a moment, Manox. The records were lost and Manox the drop.
And then you just go in for public notices. How are they entitled to?
But they are not entitled. That is
No. How are they liable? Because you put up a public notice. You take their EMDs, you lose the records, you don't inform them.
You inform Manox.
That's the question. How did you inform them? You had no particulars.
That is my case, Manox.
That is the reason why you couldn't inform them, and you go in for a public notice and say that they didn't come forward.
Ridiculous. So therefore, Manox,
it was your responsibility to retain your records and keep them safe.
How can Manox?
There is a question of
2008, 2000 Manox.
You can't just wake up and say I pocketed your EMD, but I'm not going to give you a plot now.
Manox will kindly see, Manox.
It was supposed to be a state instrumentality. model citizen, not this kind of underhand tactics.
They filed a writ after 17 years, my lords.
Maybe so.
My lords, now kindly, my lords will see, my lords, page 29.
Sorry, counsel, we are not going to refer this.
My lords, then kindly the cost be waived, my lords.
The counsel is there on caveat.
No.
Someone is there on caveat. No one is here. Without the counsel agreeing to it, we are not going to waive.
My lords, they are not opposing, my lords, being on case. My lords, nobody is appearing, my lords. My lords, kindly waive off the cost, my lords.
19 allottees, so into 2. 38 lakhs you'll have to pay.
My lords, only one. Here,
Only one.
Yes,
Only this person.
Here, my lords.
19 allotments were there initially.
Only one allottee has challenged.
Then only 2 lakhs.
Then be happy.
He has come forward.
You can afford it. We find no good ground and reason to interfere with the interim judgment. SLP is dismissed.
May it please.
Yes, Mr.
In respect of your lordship may see that part of the order that is set aside by the High Court.
34 court.
Yes, please see page 26. There's no reasoning whatsoever.
Where? Page 20?
26. 25, your lordship may see. With regard to CMP number 30 of 2023. That's one part of the damages.
Where are you reading?
Well, let's
looking at the wrong file.
Lordship have page
67.
25.
Oh, sorry. 67. Page 25.
The lordship sees paragraph 2 at the foot of the page.
Yes.
The learned principal district judge has partly allowed the arbitration OP, setting aside the award under clause 5 for rupees 5 lakhs towards damages, loss of reputation, mental agony, as well as the interest awarded under clauses 7 and 8. Aggrieved by this decision, the present appeal has been filed. After perusing the detailed reasoning assigned by the learned arbitrator in the award and considering the law laid down by the Honorable Supreme Court, we find that the appellant's claim petitioner is entitled to compensation for loss of reputation and interest. Accordingly, that portion of the award that was set aside by the principal district judge is hereby reversed, and the compensation of 5 lakhs along with interest awarded under clauses 6, 7, and 8 is restored. Exclusion of interest clause is also set aside and claim petitioner is entitled. This is the only reasoning on this aspect.
And this is a distributorship agreement.
Correct, Mala. So that's one point.
What is that old judgment, that Amritsar gas service? Saying that this agreement is not, in fact, because section 14 of the specific relief act, it is terminable in itself.
And the second point is, even on merits, there are admissions by her as regards the irregularities.
Issue notice, returnable on. You'll need a stay of operation of the judgment.
Stay of execution proceedings.
We'll stay the operation of this judgment. Maybe. That's why I'm aware of the public gas service. 15th September, operation of the impugned judgment shall remain stayed till the next date of hearing.
Lordship.
Maybe.
Yes.
The page 12 mil of the National Commission. The revision.
The DLF Homes Panchkula is relied upon.
Apply at all.
How does it not apply? Multiple compensations.
Yeah, there is
For
no
the same deficiency, multiple compensations.
Lord, I'm sorry. In my case, refund order. Lord, refund order, because I asked for refund. There is a primary relief that I asked for.
Refund.
In my case.
Let us see your prayer.
Yes, Lord. Complaint is 68.
Refund plus compensation plus 5 lakh compensation plus 20,000 plus 3,000 costs.
Yes. Compensation is a separate head, Miller, under the Act also.
No, but how many compensations were you given? What is the refund amount?
Refund amount is 20 lakh and all.
20?
The amount which he had received, 20 lakh and all.
That is the refund amount. So the NCDRC has now set aside which amounts?
Compensation of 5 lakhs.
20,000.
That's right. Compensation, Miller, the compensation distinct head once you have found that there is a deficiency of service. Lord, the distinct head under
Why the separate 20,000 again?
that, Lord, may not come, Lord, within the, it may.
Now you're asking for a higher interest rate also, without going before the NCDRs.
Yeah, I did not go, Lord, of course.
Where is the question?
They would not press me, Lord, because I did not go before the.
Then
But then this 5 lakh thing, Lord, they could not have.
consider issue notice, returnable on 15 September. Delay
Lordships, before going into the question of Lordship's consent decree.
It's not a consent decree, is what the High Court says.
But what I am
Impersonation is what is.
is that this is a hopelessly time barred without limitation appeal.
Because this lady is impersonated, someone else appears as her and then gives evidence. That is her claim. Once that is her claim, then obviously the limitation can't start ticking from the date of the judgment.
See, the High Court has not gone into.
Case control and appeal is appealable, held appealable.
I may be right or I may be wrong, but Lordships, limitation is a point, Lordships, which I am pressing, Lordships.
This limitation may not really start.
See, here, Lordships.
Decree is dated 5/12/2003. When did she wake up?
Order 9, Rule 13 application was initiated on 17/8/2004, Lordships.
17/8.
Lordships, take it, Lordships.
Where do we get these details?
Lordships, Lordships may get it, Lordships, in the application itself, Lordships.
2004.
And there is no dispute on that. The knowledge alleged is 10/8/2004. Now, the most important fact I am pointing out below. The respondent filed a suit to declare the decree void, Lordship. That is at page 60, Lordship, 60. Declaring herself to be an indigent person. Now, Lordship may see page 61.
Yes.
She alleged that she got knowledge on 21st August 2006. 6th line from top.
Yes.
3rd line from bottom, it has been stated in relief. 1. That the decision of decree obtained on 5th December 2023 from the Court of Senior Division Civil Judge, Farukhabad, in favor of plaintiff applicant such and such, by hatching conspiracy and deceiving the plaintiff applicant, should be declared void and ineffective. And the order regarding its set aside should be passed by the against the defendant. Now she filed a suit with this indigent person. Now, Lordship, this is the order dated 28/11/2007, Lordship, page 660. And Lordship, this has been dismissed. This has been dismissed, Lordships, at page 65.
Holding that she cannot sue as an indigent person.
Yes, exactly. But
Yes,
Lordship,
we got that.
here, from 28/11/2007, so she has not filed any case. Lordship, this suit, she ought to have been filed, Lordships. Now, therefore, Lordships, my respectful submission.
When did she file this appeal now?
Now, this appeal has been filed, Lordships, in 2000, this appellate court. This has been filed long after 10 years, Lordships.
2017.
2017. Now, my respectful submission, this suit has been filed in the interregnum period when Order 9 13 application was there.
Let us see, counsel is on caveat. How do you explain these kind of delays on you?
To 2017, I continued pursuing my remedy.
After 2007, what did you do?
The 2000 application there in this suit. Thereafter, that got dismissed. That was only.
This is the 2007. After 2007, what did you do?
913 was dismissed in 2013 only.
Where is that?
13, Lordships. Not in this case, Lordships.
In this case,
In that again, a set aside was fine.
Lordships, here.
No, 913 was dismissed earlier itself, you said.
Just I will not mislead, Lordships. Lordships, 913, as I submitted, Lordships, it was instituted on 17/8/2004.
But remained pending for 9 years.
Lordships.
9 years it was kept pending.
And Lordships, she ought to have taken states. When suit has
So
been
after 2013, what were you doing?
In High Court, it was
When?
17 only.
Your writ petition is of 2013.
The earlier writ petition, earlier round of writ petition.
Where is that order?
page 82.
82.
High Court.
Lordships, may I point out, Lordships?
But if she was continuously litigating, it's one more.
Order 9 Rule 13 continued, Lordships. I am not saying no.
Counsel, that is also not correct. Page 82 is a 2017 writ petition.
That's correct, my lords. This is the
2013 to 17, you kept quiet.
Yes.
Filed. It was
More than that.
filed.
It won't be numbered after 3 years, 4 years.
My lords, it was filed. Kindly at the last paragraph also. It is how, for all the above noted reason, this court is of the view that the court below was.
Where do you get it that this was filed in 2013, Counsel?
I have to check, but in this order, what the High Court did, the High Court granted me a liberty to go for the appropriate proceeding. After that, I filed this.
It is an observation, Lordships, appropriate proceeding, Lordships, appeal. But Lordships, question remains.
If you're not at the same time, let him answer thereafter. Yes.
Honorable High Court granted.
No, but you're not able to demonstrate that this was filed in, so at least 4 years delay is there on your part. Especially when you're claiming that you were impersonated.
No finding, Lordships. She should have, Lordships, filed a suit in 2007 itself, Lordships, my respectful submission. How can she get pending Order 9 Rule 13 for such a long time and then file an appeal?
You can't blame the court's delay on her.
Court's delay. I'm saying that Lordships, suit as an indigent person was decided in 2007.
That was on the ground that she should have entitled to sue as an indigent person.
Also my case, that was also obtained by an impersonation. That is my case.
Thing is impersonation.
So obtained by impersonation because
But it's not filed by you.
Only allegations, Lordships. High Court has not dealt with it.
Proceedings in 913. And in the meanwhile, that was filed. So my lords, open with the appellate court.
It's just on allegations,
Got
Lordships.
somebody to impersonate as appear as DW1.
My lords, the order sheets also.
These are all allegations, Lordships. She is mother-in-law, Lordships.
Not a mother-in-law.
She is mother-in-law, Lordships.
Archana is the first cousin.
Archana.
First cousin of her husband.
Instituted by Sushila.
Sushila Devi sued her son and daughter-in-law.
That's right.
You stepped into the shoes of Sushila Devi.
Yes, I stepped into her shoes. But Lordship,
Property was bought in the name of Arun Kumar and Baby Rani.
Lordships, there are two properties. Lordships.
Anyhow, it's better that you face the litigation. There are too many imponderables here for us to venture an opinion.
There is no
Anyhow, we are not interfering with this. Let the appeal be heard. Thereafter, if she is able to demonstrate her case,
Only one.
we are not going to nip that appeal in the bud.
Only one thing, Lordships. Impugned judgment, page 17. Now see para 47 and para 50, Lordships. In this, the observations of the High Court, Lordships. At least
suit was filed.
This should not have been observed, Lordships. The appellate court ought to have been given, Lordships, a free hand to decide the case.
It appears, they said, there is not a finding.
It is very hard case where it appears.
Appears that a collusion.
Lordships, the appellate court will go into this, Lordships. Para 50 on the front. What by respectful submission?
Well, that will take care of.
Made in this.
We find no good ground and reason to interfere with the impugned judgment passed by the High Court. Especially petition is accordingly dismissed. However, we make it clear that the appellate court shall proceed to hear and decide the appeal on its own merits and in accordance with law, uninfluenced by any observations made by the High Court or by the dismissal of the special petition. Yes.
Lordship, item number 70, I am led by learned senior. She is appearing through VC.
May I please, your Lordship?
Yes.
Lord, the High Court has not only reversed a well-reasoned order passed by the trial court,
which had balanced the equities and kept the matter, my lord.
You already lost in an order 39 rule 1 petition.
My lord, never lost.
Again,
Please have a look at the order.
This.
That's, my lord, the ambiguity.
And those
the
four
trial court.
FDs don't even exist. The FDs were already encashed by him and
no, my lord, they were already there in account. Allow me just one moment, my lord. Let me dispel two impressions, my lord. First, my lord, the High Court thinks I never made a prayer. I made an exhaustive prayer in the civil suit that all FDRs ought to be, my lord. There should be injunction. Two, my lord,
the FDRs were all FDs.
My lord,
you can't just say all FDs and leave it hanging.
My lord, now
the suit schedule needs to give the details of the FDs.
My lord, your lordship may just give me, my lord, one moment and I'll satisfy your lordship, my lord. How the trial court, my lord, when I went, the trial court said that I'll call for the records. I will pass an injunction order only when I hear the other side, not before. It never rejected it. The order is reproduced, my lord, in the now impugned order itself. Your lordship would have a look at that. Please have a look at the earlier order, which is extracted, my lord, at page 13.
Yes.
Just have a look at the earlier order. It didn't decide any rights. It just deferred the consideration, my lord. That order is, my lord, in para Roman 1I.
At this stage, no ground is made out to grant ex parte
stay. And this deems it appropriate.
Thereafter, that application, what happened to that application?
That application got decided now. What happens is, my lord, this is the impugned order which was passed by the court.
This application is filed by the bank, not your application.
No, that's what I'm saying, my lord. The policy of the bank said, the High Court felt that the moment person is either or survivor, the bank is obligated to provide them unimpeded access. That also is wrong. If your lordship would have a look at the policy, page 15. Just
You're not telling us what happened to this IA filed under order 39 rule 1 and 2.
This is pending, my lord.
Still pending.
Still pending.
Then you obviously didn't follow up.
No, my lord, because in the meantime, this happened. Allow me to read that policy.
You inspire the bank to come up with an application.
No, my lord.
How is the bank
please see page 30.
File that application after allowing him to encash the bank guarantees?
If that be so, my lord, I'll be out of. My lord, allow me just one moment. The bank's policy said that you will allow unimpeded access to either a survivor, but if the matter is sub judice in a court of law, you will be guided by the court's orders. It is these circumstances that the bank went.
But do you deny the fact that those 4 FDs were encashed by him and converted to 2 FDs in his own name?
But that's not internally, because bank did not allow the encashment.
Then once that happened, there's no question of your turning
there
back
is an
the
earlier
clock
bill of
back to those 4 FDs now.
Dispute is of 2 bills. The earlier bill said everybody 20%. We are all nephews. Lord, the second bill.
Now you got that 20% at least.
No, my lord, nothing. She's taking by virtue of this. He's taking by virtue of the new will of 22. He's 100% now. We are ousted. This is, my lord, absolute abuse of process of law by him.
FDs were also in their names jointly, either or survivor.
Either survivor.
You were not in the picture at all.
Allow me, my lord.
That's the question of your
lady was living in. My lord, this lady was living in Singapore. She was invalid. She was not in a sound disposing
mind. Will has already been probated.
My lord, that's what earlier will also, the High Court calls it unregistered. It is duly notarized bill, the first bill. It was already in existence. He took, my lord, a power of attorney from Singapore. Under the Singapore laws, a power of attorney is only taken when a person is not in a position to execute.
The facts are entirely against you. Once those 4 FDs went, there is no question of your now turning back the clock.
My lord, I am only beseeching your lordship. The matter was before the trial court.
Sorry, Mr.
All right, my lord, could your lordship then say, my lord, only this much, that the High Court's findings would not prejudice the trial court, it will independently decide my application.
High Court has itself said so.
My lord, your lordship may just clarify.
Paragraph. Please look at the concluding paragraph.
No, my lord, but then after so many observations.
Said so. In fact, there's a reference to the order 39 rule 1 and 2 application also. I missed that.
My lord, could your lordship
shall be decided independently.
My lord, so in the wake of this, my lord, I will not press this petition. Your lordship may say that. In the wake of this paragraph, your lordship may, my lord, make an observation.
No good ground and reason to interfere with the impugned judgment at this stage. Mr. Chaudhary, senior counsel appearing for the petitioner, states that in the light of the observation made by the High Court in paragraph 17 of the impugned order to the effect that the suit and the application filed therein under order 39 rules 1 and 2 CPC should be decided independently without being influenced by any observations made in the body of the impugned order, does not wish to pursue this special leave petition. The special leave petition is accordingly dismissed as not pressed.
Will not consider omitting the first line.
Which one?
Second bit. Your lordships don't find any.
Well, we were inclined to dismiss it.
I know, my lord, but since your lordships have allowed the second one, let the first not to be there. Deeply obliged, lords. Deeply obliged. Very grateful.
Make this, your lordship. Let's.
Are you a tainted candidate or are you not? Then who are you then?
We are all the writ petitioners who have challenged it, my lord. We could not, my lord, be selected because of this, my lord, all illegal procedure. That's why
the order says that all untainted candidates and those disabled candidates would be. What more do you want?
The difficulty is now, by virtue of this notification, they have added the new vacancy.
That we are not going to go into.
No,
we never said that the rules will stand frozen though.
My lord, kindly see, lord, this court directed that they will not get any advantage of this.
We did not say turn back the clock and start from there.
Oh, your lordship had said that the
only granted age relaxation to particular categories. I think the disabled candidates.
MA application, lordship was categorical that no advantage would be given to them. Now they, by virtue of amendment of rules, 10 marks is given benefit to them.
No, we are not going to say that. Where have we said that we have frozen the rules or the para? Come to the conclusion, page 406.
It's without judgment, which is at pilot.
Come to the operative portion, the conclusion.
Yes, operative portion of my letter.
Where have we said anything that helps you?
Page 46, kindly come to that.
Para 46.
Yes. The last question relates to relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of tainted candidates who were appointed must be terminated, and they should be required to refund any salaries, payments received. Since their appointments were the result of fraud, these amounts to cheating. Therefore, we see no justification to order this direction. Then second, for candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violation of illegalities which violated Article 14 and 16. As such, the appointments of these candidates are cancelled. However, candidates who are already employed need not be asked to refund or restitute the payments made to them. However, their services will be terminated. Furthermore, no candidate can be appointed once the entire examination process and the results have been declared void. Then,
Para 47 may not be relevant.
And we come to Lord 48 and 49. 49 is very important. The disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. Similarly, other candidates like us.
But not specifically tainted.
But not specifically tainted will also be eligible to participate with appropriate age relaxation. In our opinion, such a direction would be fair and just. Then they filed an application, MA application. And this court was kind enough to pass an order in the MA application. Kindly turn to
those who are working would continue to work till the end of the year.
And then again, kindly come to the order passed by this court.
Which order?
That at page 426. The state government, the applicant.
26.
426.
26. Give me a second. Yes.
But the advertisement for fresh recruitment to the aforesaid posts. Therefore, the Supreme Court was very categorical. There should advertisement for the posts which are declared to be nullity by the judgment. Therefore, they can alter it. Shall be published before 31st May. Then, the entire recruitment process. Then, kindly, skip over. We clarify after paragraph 4. This order shall not be read as a conferring any special right or advantage on the aforesaid teachers insofar as the fresh recruitment process is concerned. Now, by a sub-legislation rule, they have really tampered with this order. Kindly,
where have we said anything about what kind of rules should be applied? We said fresh recruitment process.
Recruitment
Obviously, the service commission is entitled, the authorities concerned are entitled to
And excuse me,
have a higher standard if they choose to. How can you say, no, the standard should remain static for all times to come?
not at all bothered about the standard. We are all.
This is, if they
They cannot
post a new condition, that's obviously to see that they have better standards.
not get the advantage of 10 marks additional.
No. We have not said anything on this.
My lord was kind enough to say that they will not get the advantage of that. Now,
Who would not take advantage?
the teachers whose services were terminated.
That the service commission should not take advantage.
No.
This order shall not be read as conferring on the aforesaid teachers.
So,
Therefore, how are you twisting it around to apply it to the?
Allow me. By making rules, they are giving advantage to teachers.
No. How are they giving advantage?
Just
how will you know how they will fare in the exam?
These additional 10 marks for teaching experience, which was never there. Kindly turn to the page.
We are not inclined to entertain this.
Kindly.
This process, I think, needs to go on. This amount of litigation which is going on.
The court, if
this will go on endlessly.
Just 1 second. The court directs that there should not be advantage to the teachers. Now, if the rule says
they will not take advantage. We never said don't give advantage to the teachers.
Yes.
We said the teachers will not take any advantage.
No, they will not get advantage, but they are getting advantage. By rules, kindly see, by rules, they say now the additional 10 marks, which will be kindly turned to 46 marks.
We are not going to.
Kindly have a look at it. Otherwise,
sorry, counsel.
This kindly will not have, kindly.
If they do have teaching experience, that is good, is it not?
This experience, the appointments.
Whether you like it or not, they do have teaching experience.
So, if the appointments are declared void,
And also they have teachers.
if the appointments are declared void,
we allowed them to continue to teach.
No. I am not clear. That if the teachers who doesn't have the valid appointment, would they get the benefit of that?
Do not know how the rule will be interpreted.
The rule is very clear.
You may have no. We are not going to preempt the exercise by not considering what that rule means.
I'm not asking that the school service.
At this stage, we are not going to interfere.
Kindly look at it.
Not at this stage.
446.
So I'm sure you'll go back to the High Court once again. So we'll have some occasion to look at it once again.
Trouble to see at least one page.
Sorry, counsel.
That this will give advantage to the tainted teachers.
How will the tainted teachers? Tainted teachers are not even eligible to apply.
These
tainted teachers are out.
Have been without the negative.
They are out.
Now the teachers who
are untainted. If they do get the benefit of teaching experience, how are you?
But the question is, if the appointments are declared to be void, would that experience be counted? That's a valid question.
We said that their appointments cannot stand because the entire process is wiped up. Not that they are liable or responsible for it.
No. Again, this is the question of liability. Sorry. If they get.
We find no good ground and reason to interfere with the impugned judgment, especially when accordingly
discrimination.
That is also dictated now. Sorry. Pass overs.
Can see.
Item 1. Where were you in the morning? First item, you don't turn up.
I am outside, but I am outside the court.
One thing should be clarified. No, we have been given the age relaxation also.
The council have also left.
The age relaxation should be granted.
Sorry?
Age relaxation.
That the order itself says so.
That they are not permitting us.
The order, once it specifies that all untainted candidates will be given.
They have. Yes. Age relaxation should be granted. Lordship, can you clarify that?
But age relaxation, your lordships have granted in two type of cases.
No, all untainted candidates. They are not tainted according to them. They were not selected at all.
Your lordship's categorization was untainted and tainted in the judgment. Tainted and untainted in the judgment. Your lordships have dealt with that.
That is
untainted case, your lordships have granted age relaxation on two types, untainted and disable. Neither they are coming under the untainted because they were not serving. They were not serving at all. Therefore, they are not entitled.
Tainted candidates, we are candidates.
Those who are within the age criteria, and there cannot be a division of new employment has to be generated.
The candidates who are not tainted, they should be given the relaxation. That's the order.
You are not tainted.
Not working, but they participated.
That's the basic thing.
This is on the selection which we have satisfied. Should they have a second opportunity?
For page 40.
Only to tainted and tainted. Tainted would mean that they are already in the frame. No, that is the way problem. If you were not even selected, you were not selected, is it?
The process was directed to be done after.
If you were not selected at all, you were not in the picture.
All below.
One of the candidates who appeared and did not figure in the select list, waiting list, you were not there in the picture at all. So there's no question of giving you the title of untainted candidate.
No.
Untainted candidate in that context in the litigation was in the context of those who were already selected and appointed or in the waiting list.
Yes, not in the waiting
Those who were tainted, those who were not tainted. Were you in the waiting list?
Yes. Look, we are.
Select list. You were in the select list. No, were you in the select list? So how many candidates were there in the waiting list?
They were not in the waiting list.
They were not in the waiting list.
They have not, what they have done, in the averment they have said, all we are untainted category.
No. Those who participated are not entitled.
They were not selected at all.
Then
they were not even
you're not there in the select list, you're out of.
Selected persons cannot be allowed to go for fresh selection. When fresh selection, it should.
If you were there in the select list, then the question would arise whether you were tainted or untainted. If you were not even selected, that title would not extend to you.
We are entitled to participate.
Who are you?
We are the candidates. That's the judgment.
Who did not figure anywhere in the selection.
The selection was.
It is not that we are setting back the clock for the entire 25,000 who have. That is not what it means. We have said untainted and disabled candidates.
What shall
the entire lot is.
Kindly see.
Will allow me to read the judgment.
Nobody is enjoying a right. Rather, your lordships have put a stringent condition on us that you have to complete the selection process.
You are for the service commission.
Yes. Lordship's object was that better candidates should come.
Without any manipulations. Without manipulations is the more important thing.
And only two exceptions have been made. Those who are untainted in employment, there should be an age relaxation, and those who are they are in that.
May I just explain? Lordship will not kindly. Kindly listen for a second.
You are admittedly not in the select list.
How could it be? Because the selection process.
Or could have been is a different thing. Speculation, Mr. Rahim, it can't be. We are not going to.
The state devises a new formula has to add changes or.
No, that's how our order reads. When the time we passed the order, you never said that all the 25,000 candidates who applied earlier, minus the tainted candidate, should be asked to. That is not the order. That is not the order. We have specifically used the word tainted and untainted.
That is the selected. Tainted, I think, is the word appointed.
The word tainted, untainted necessarily has to be in the context of the select list.
The appointees, not
the list, select list. If you do not come in the select list, you're out.
My lord is not directing me to have fresh selection only for the select list.
That is exactly what it means. You have to understand what the order says. It says tainted, untainted. If you are not even selected, where is the question of calling you an untainted candidate?
Directing fresh selection for 2016 for the vacancies.
Sorry, that understanding perhaps is not.
May I read my lord's judgment at once, my lord?
We have already, I was there in the bench and I discussed it with the Chief Justice. We had a meeting over the weekend to discuss the judgment before it was pronounced. So you don't need to tell me what exactly we intended.
It was very kind.
Chief Justice took me into confidence on every aspect before he finalized the judgment and pronounced it.
And taking advantage to Mullah.
So I'm telling you, our understanding was never that all 25,000 candidates should be allowed to appear. except those who have been found tainted.
Kindly come to my lord's order.
That was never our understanding. That would be entirely unwieldy. Where is the question?
Otherwise, what would happen?
If you did not even pass in the earlier,
Fighting that the manipulation prevents us from getting to selected. And the court ultimately finds the entire manipulation and directs that it should be afresh. But what is the meaning of afresh then? And court also says the declared vacancies. Kindly come to me that my lord's order.
so far as the age relaxation is concerned, that is the only relief given. Disabled candidates and untainted candidates. You are not untainted.
Will not be selected.
If you are unfortunate enough to have crossed the age bar, then you're out.
No, my lord was categorical saying candidates, did not say without the appointed candidates. He just give
Untainted, we've already explained for the
untainted means without
time. I'm telling you, untainted obviously is contextual to the select list.
Then 3,50,000 of 2016 who applied for that.
Then no. Sorry.
My lord,
Sorry. We have heard you. Sorry, we are not going to open that door.
Partisans, but kindly take some my lords that this order will betray the earlier order of the court. Kindly come to the MA order. Once, kindly. See.
You may have been litigating, but if you cross the age bar, sympathy, but nothing more.
Come to the MA order at page
426. Yes.
May I read it, Willard? An advertisement for fresh recruitment to the aforesaid posts. Aforesaid post means the 2016 vacancies, which have been under the consideration of court. Court found that the entire selection was bad. If the entire selection was bad and manipulated, then court directed it afresh. Therefore, why should we be debarred from participating?
No.
And that's the consideration of court. And the court had said that those who are not tainted, they will have the relaxation. We are not tainted.
338.
Yes. March.
Was upheld by this court.
Fresh selection process in respect of the declared vacancies.
The vacancies may be frozen. That doesn't mean your candidature is also frozen.
The lordship that the vacancies are frozen, Lord, then the participation, Lord, of those parties who had participated should be allowed.
13 also today, Lord,
we have been fighting for years together. We are not getting relief.
I don't think we can. Sorry. We find no good ground and reason to interfere with the interim judgment, especially petitions dismissed.
No, it's better.
Yes.
Permit us to withdraw this.
After this length of time, we do not.
It happens.
No, to begin with, we are completely
I thought will be kindly consider because
against this practice in the Supreme Court of trying your luck and then backing out. This system, this is a very unhealthy practice. At some point of time, it has to end. SLPs are not gambles.
Here,
that you try your luck and then you take back your bid.
I appreciate.
That is exactly what all of you do. It's a very unhealthy practice.
These, of course, without, in my humble submission,
Sorry, we are dismissing.
has created the bad
We are dismissing it. That is all there is to it. Sorry. Whatever it has to go on now. I think enough has it. Whatever it is, let the process go on now.
They play fraud and taking advantage.
Item 1. So where were you in the morning, council?
Just enter, my lord, but item number 2 is going.
Weekend hangover. Sunday, yesterday. Weekend should be on Saturday, not on Sunday. It affects your Monday functioning. Yes.
Transfer petition, my lord.
Next party, my lord.
Your Lordship, I apologize for. I was there online, Your Lordship. I've somehow
not able to log in. Very. He served, not appearing.
Despite service.
But your.
Much obliged.
Out of 31 list of witnesses there, out of 31, only 17 has been examined. And
where do you get the list of witnesses? 17?
17.
31. 31.
list of witnesses there on page number. That is page number on, just a minute, Lordship. Yeah. This is on page number.
Charge sheet would mention the
47, Lordship. 47 page number. 47 and 48. This is the last page. There is 31 witnesses and 17 has been examined and others are left for examination. So I
They
have.
might give up witnesses. It's not that all the listed witnesses will be examined.
Those are
It's not. The prosecution shows a lot more witnesses in the list of witnesses and ultimately give up a lot of witnesses. So maybe we do not even know whether they will end with 17.
Yes, sir. 17 is on page number, Lordship. The 17 has examined, that is on page number 194. This is a PW 17.
There will be order notice, let them come forward, then we'll see. If the state says that it's giving up n number of witnesses and the trial is at an end, then we will not be inclined to interfere. Learned counsel for the petitioner states that 17 out of 31 witnesses have been examined and the trial would not conclude anytime soon. He would point out that the petitioner has been in prison since 25/10/2020 as an under trial. Issue notice, returnable on.
Lordship, returnable on, please.
On?
Returnable date, Lordship, please.
Yes. 110. Sorry, 19. 19. Service shall be effected by all modes, including this. Delay conduct.
I could not file the online appearance. Kindly, please take. Sir, sir.
15.
My lord, I am behind bars from 16 months. Charges are not yet framed, my lord. There are 40.
The money was from you.
Yes, my lord.
512 grand.
512 or 186? What is this? Two quantities are mentioned. High Court mentions 180.
Different accused.
It can't be split up like that. If three of you are together, all three of you will be attributed the full amount. There's a judgment which says you can't split up the seized amount amongst the three people if they're carrying it together.
Duration. Charges are not yet framed, my lord.
You have past antecedents also?
Oh my lord, there is no antecedent. 49 witnesses, charges had not been framed.
MD is a very dangerous drug.
Mephedrone.
Yeah, MD. No,
You've only been there for a year.
X was also recovered from you. You're a drug peddler.
I am disputing, my lord, the procedure.
But the quantity, it is well above the commercial quantity. 50 grams is the commercial quantity. If at all we divide it also amongst the three of you, it comes to 186 in your possession.
These are the allegations.
And how many past cases?
No, my lord.
How many past cases?
No history, my lord.
No history.
Charges are not yet framed, my lord. It will take, I think,
No.
longer time.
Commercial quantity is there.
49 witnesses, my lord.
Right. This amount, it's obviously not for self-consumption. It's obviously a peddler then. Three of you carrying it together, obviously it is not for your own consumption. You are peddling it. Three people were caught together.
I am disputing this yet to be ascertained by the trial.
Oh, but on the face of it, that is the allegation that you, along with two others, you were carrying 512.2 grams.
These synthetic drugs are very dangerous.
No criminal history, my 25-year-old yet to
It's commercial quantity, and obviously you're involved in the marketing of this, going by the quantity that is involved.
see, my lord, page number 66. There are 49 witnesses. 5 accused.
उसका उम्र के हिसाब से notice करें.
One has.
We'll find out what the situation is. Issue notice returnable on 8/9. Which shall be effected by all modes, including this. Before that, first sentence, learned counsel for the petitioner states that the petitioner has no past criminal antecedents.
My apologies for not reaching on time.
Yes, Mr. Shankar Narayan.
This question,
Everything you can raise under section 16.
issue is now.
Is that
this
defined
is-
as 16?
May I?
So it has been argued also. Then sailing on two boats.
Let me just, it's only one court, it's only section 11.
No, you went before the arbitrator and you now want to
Section, or in the section.
challenge the appointment of the arbitrator.
Section 11. This was a square argument. And if I can just hand up this chart, because this is pending in this court. This issue of invoices, which are subsequent to a contract, where an invoice is sent, in that invoice, and in this case, in an E and OE clause, right at the very bottom. Just give him one second. Just see this, Manoj. The first one is a Scholar Publishing House. I have marked in this middle column what the Delhi High Court judgment is. If I can just see para 7 and para 10, which is extracted. In newsprint sales, the learned single judge noticed the Bombay and Calcutta High Court decisions and concluded correctly, if one may say so, that there is no straitjacket formula to say that such invoices cannot or can amount to binding arbitration clauses. The decision correctly surmised that the views of the other High Court have stressed the necessity to consider the conduct of parties evident from the record. Therefore, in newsprint dealing with the facts in question, the learned single judge concluded that there was no agreement. In the present case, there's a wealth of material in the form of more than a decade of commercial relationship during which identically phrased invoices containing the arbitration stipulation were accepted and acted upon. Now, in these circumstances, my lords, the appeal came to be filed in the Supreme Court. It's a batch of cases now. These are just extracts of 2 orders, but it's a batch now. Many issues have been tagged. Many cases have been tagged, SLPs have been tagged, and these matters are pending. Specifically on this one question, on the second page, if your lordship sees, you'll find the judgments which are in my favor, but it's split between the high courts because the high courts have gone the other way. These are high court judgments going in my favor. But in fairness, I must tell you that your lordships have not adjudicated this issue. In this particular issue, just see page 76 and 77. Because the court has come to the conclusion looking at these 2 documents, 76 and 77. Identical documents go all the way up to page 140, but just see this first sample. 76 is a confirmation letter. Now, this is the letter that is sent, which lays down the terms and conditions. Middle of the page, you see terms and conditions. Not a single stipulation about arbitration. This is dated 4th April 2017, which is sent between them and us, and it is agreed. No arbitration clause. Next page, page 77, is the invoice. This is what they are relying upon. The date of the invoice is the top right hand, 28 February 2018. It's sent by them to us, unilateral. Now, in the middle of the page after the box, you see E and OE. That's errors and omissions accepted. It's a term of art, it's used internationally. It's only meant to limit liability of the person sending the invoice in case there are clerical errors.
What does it stand for? Error and?
Errors and omissions accepted.
Accepted.
So that is what this clause is. Now in this clause, this is even stronger than the other cases pending before your lordship. In an E and OE, they slip in, if your lordship sees second last line, dispute, if any, shall be decided under Arbitration and Conciliation Act 96 subject to Mumbai jurisdiction, to which we, in handwriting at the very bottom of the page, in handwriting, received 3rd March 18, not checked, and the signature.
But this was in 2018. Did you ever raise a protest saying that this, what you've said in your invoice, is contrary to the confirmation letter that
document? Because they went to the
2018, you must have acted upon this.
I've said not verified.
Please wait till the other cycle.
I have said specifically here, received not checked, after which we never responded to them. Second, we have.
But how many invoices were there over a period of time? How many such invoices did you receive?
3 years, 1 year, 2 years.
30 invoices.
30 invoices.
Invoices which are sent subsequently.
If you never protest, then it must be taken. Even if there's a deemed acceptance also. Arbitration need not be.
The invoice is for the purpose of what? It's to tell me the amount. So regarding the amounts, we protested on every single one of these.
No, you said also that not checked. So God knows what kind of checking you go in for.
Regarding putting up of hoardings. So wherever they put the hoardings, this invoice doesn't tell me which
Now,
hoarding.
anyhow, you've raised the section 16 objection. Then.
Without protest, because this judgment stood in the way, without protest, I filed a section 16 and there is a
Then
section
once you
17
raised it, once you've initiated that, why should we stall it now?
The problem is the judgment says that I've acted upon this. Factually incorrect. And I've specifically, if you just see page 5, and then again.
If you made a payment on the basis of that invoice,
Please take it from me, not on the basis.
no, if there is an invoice, you make a payment, obviously it's on the basis of that invoice.
So when I make a lump sum payment, it's not regarding a particular invoice or a group of invoices. Page
Para 5, there's nothing.
Page 5.
Page 5.
6.
Yes.
The services were indeed covered by the invoices. The invoices were accepted and partly paid for without challenging the arbitration.
Which is also a fact.
Not accepted. They were not accepted.
No, you accepted the invoice and made some part payments.
Not. This is the very.
You've not made any payment at all.
Have made.
Then obviously on the basis of invoices then.
Your Lordship may take it from me. It's not
On the basis of which invoice did you make it and did it not contain an arbitration?
Because we have an overarching agreement on which I will make payments. That's why I showed you the confirmation letter. The confirmation letter is the one which lays down the terms and conditions.
But if that was the case, then you did not have asked them to raise invoices at all.
No, I didn't ask them to raise invoices. They raised invoices and I said, I don't know which this invoice is for. I made it very clear. This denial is accepted by the NCLT and the NCLAT when they went to
Anyhow, the arbitrator sees doesn't matter. Why are you worried about this stray observation?
You can see where this is headed. So
no, but once you chose your remedy, you can't have these parallel remedies.
All I'm saying is, leave me the liberty to argue this in my 16 because
you already.
No, I uninfluenced by this order because
you already argued it is what the council is saying.
It's not finished. It's on its way without prejudice. The reason it's without prejudice is because the remarks here have an impact on the argument there. I'm in fairness telling your Lordship.
That is all. Till I condone, we are not inclined to interfere with the
defense
judgment.
16 is that this High Court judgment has come. That's the defense.
We are not inclined to interfere with the impugn judgment and order passed by the High Court, especially petition is accordingly dismissed. At this stage, we are informed that the petitioner has in fact raised its objections before the learned arbitrator under Section 16 of the Arbitration and Conciliation Act 1996. If that be so, the said objections shall be considered by the learned arbitrator on their own merits and in accordance with law, uninfluenced by the dismissal of the special leave petition and the observations made by the High Court in the impugn.
Lord, here, your lordships, the only issue that was left, because we placed it last week before your lordships, is as to what the resolution professionals.
Now the resolution professional has.
Now we have filed an affidavit saying he does not need the. When last week, this is where we parted.
Yes, we've got give the affidavit.
I make a submission. I appreciate.
Go for R1. Yes.
Question is whether the resolution professional now says that they require the property or not. The point before the NCLAT was that the issue under Section 14(1) is never added. It's not considered by COC, not considered by.
See, please let us see what Section 14(1)D says. IBC then.
My lord, as far as
IBC.
yes, my lord, it's a moratorium, my lord.
No, please look at the wording of it.
Subject to the provisions of subsection, my lord, has it?
No, page 19.
Subject to the
Yes.
provisions of subsection 2 and 3 on the insolvency commencement date, that's immediately, my lord. The adjudicating authority shall by order declare moratorium for prohibiting all of the following, namely, now D, the recovery of any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor. And it's fairly covered.
Now, once the resolution professional says, I don't need this premises, he is the person in management of the CD. Once he says, I don't need it, it is not for you as an erstwhile director who doesn't even want to take any financial responsibility. Then you were already asked whether you would be willing to pay. You said no. Pay then. Are you willing to deposit 1 crore? Pay 1 crore immediately, then we will stay the order. Please pay the amount. Who is going to pay this cost now? The RP says, I cannot afford this kind of rental. You can't just say that I will rely on the statutory provision. I will not take any other responsibility. Where is the question?
The resolution application.
Or
The moratorium is to keep the property.
that is It is for the RP to decide how he wants to put the affairs of the CD in order. Once he says that he does not want the premises, there ends the matter.
Reg 14 does not admit of any such exception, my lord.
Sorry, we will exercise our 142 jurisdiction and read it into that for the purposes of this case. We are putting it to you, will you immediately deposit 1 crore? Yes or no? Yes or no? We are putting a condition upon you. Will you deposit the amount? That is not the question. We are requiring you, will you make the payment or will you not?
My lord, that
You've already said no once, so you're reiterating the no. There ends the matter. So, judgment reserved.
May I just make one?
Judgment.
I think consider, my lord,
Will-
that the NCLT granted, that's prayer, because that is only possession, nothing else.
Very.
NCLT gave us prayer. And secondly, my lord, just to finish, there is no moratorium on the COC or the RP returning the property. I can't sue for the property,
Yeah.
but there's nothing for the COC or the RP.
That is true.
visage that the CO
Very well, we'll consider.
statute doesn't
We will consider that.
My lord, should we
Yes.
2-page note if your lordship?
Very well, fine. Brief note not exceeding 2 pages,
then
filed by all the parties.
such a
File or no? With judgment? 2022. PC. You are appearing for whom? 583. 29.
Your lordships have held that if the contract agreements are not germane for the insolvency, they are not covered under the moratorium.
Right.
I just make one other submission for your lordship.
You mention it in your 2-page note, please.
So,
Well,
my lord, otherwise come out, they are attributable to the costs of the CIRP, my lord, and they will be considered ultimately when the resolution applicant comes forward.
But no, we are not accepting that argument.
Wait, please, Your Lordships. But in the morning,
Yes, Mr.
for Your Lordship's consideration, summary of our submission.
Summary of summary of submissions was here.
No problem.
Bad. Where is the summary of submissions, Mr. Mehta? We don't have it. Summary of submissions. You said morning you gave a summary of submissions.
I'm told.
Nothing was given to us.
What man?
They're saying they have nothing.
Copy, what else can I say?
We don't have anything here. And as far as I remember, in the morning, nothing was handed over. The council only said that the matter would be taken up at 2.
I was so told, my lord, that it was given to the court master.
You've been given a copy?
Oh, I've got a copy.
Yes.
No difficulty, my friend can start.
Yes, Mr.
Yes, would your lordships like to go through it, or I can?
No, go. Why don't you take us through it?
I'll just, my lord, point out at the outset, my lord, what the issue is,
Yes.
and then take your lordships, my lord, through the factual.
Hmm.
I am IRCTC, my lord, Indian Railway Catering and Tourism Corporation Limited. But I am only a pass-through entity. What happens is, this is a contract for supply of food, my lord, 2 meals, and my lord, 1 welcome drink, which, my lord, which is a separate dispute, but subject to the same arbitral award.
Okay. Good. Yes.
Lord, the scheme, the way in the scheme operates is that the amount is fixed by the railways, that you will supply both the meals, say at the rate of 120. Figures may differ, but I'm rounding off for the purpose of illustration. 120. What we do is, my lord, as IRCTC, we add that in the passenger's ticket. We recover 120 and pass it on to him.
Right.
That's our role. My lord, we come into picture, my lord, in the middle of the contract. Otherwise, railway was directly dealing with it, and that's, my lord, part of my written submissions. Now, my lord, what happens is they enter into a contract at the rate of 120. They were given later on.
You. With you or with the railways?
Railway. At that time, railway, my lord, we came as an intermediary, but the railway had the same arrangement. My lord, there's nothing.
Thereafter, you stepped into the shoes of.
Yes, yes.
So thereafter, the contract is with you then.
Yes, yes. But I step into the shoes of the railways. But the terms and condition, everything is same. The letter of award was given with 120. I'll take your lordship to the real figure, but this is not a hypothetical figure for illustration.
Yes.
But there was a master license agreement which was to be entered into with that figure which was also entered. They kept on supplying the food. We, an earlier railway, recovered that amount and pass it on to them for a period of 3 years. After 3 years, they filed a writ petition first. Writ petition, there is a prima facie finding recorded that this writ petition appears to be belated, but in any case, there is an arbitration clause, and therefore you invoke the arbitration. They invoke the arbitration. Now, in the arbitration, obviously, they would face with the problem of delay. Number one. Number two, the problem of acquiescence, because they have accepted 120, they have not raised any invoices during these 3 years, etc., etc. Therefore, they raised the ground that we were under the duress by initially the railways and thereafter by the statutory corporation. As a result, we could not protest. No invoices placed. That 120 is not the correct amount. The correct amount should be 140. No invoices placed before the arbitral. The arbitral tribunal accepted their plea of duress and awarded the amount. I'll show what is the awarded amount. I'm just giving a broad outline. We challenged that award before the learned single judge under section 34 of the Act, and the learned single judge set aside the award, holding that it is patently illegal and it is perverse. The findings are perverse. These are the two findings. Against which we partly lost and partly succeeded. They also filed an appeal. We also filed an appeal. The learned division bench in 37 reverses the decision on both counts. Therefore, both of us are now before your lordships. So that is the broad parameters. Now your lordships may kindly have a look at the chart which I have given at page 3.
Yes.
The lordships have the chart. The first date is 27th May 1999. Commercial circular number so and so. Please see, there are two meals. Regular meal, each would be 75, 75, and the total would be 150.
What does it mean? Regular meal, one meal?
Regular meal.
In lunch and dinner.
On the train, lunch and dinner.
Depending upon, yes, suppose I board, say at 2 o'clock.
Like Rajdhani and all these trains, no?
Well,
this is for specific trains, is it not? That Rajdhani or whatever.
Yes. Yes, but there is Duranto. Rajdhani, Shatabdi and Duranto. Lord, if I suppose, I put nothing turns on this, but just to understand, if I board a train at say 2 p.m. in the afternoon, then I will not get the lunch, or maybe 3 p.m. Then I'll get only the dinner and I'll be paying only 75 rupees. That's how it works. Thereafter, the tender was issued on 27th of May 2013, where the figure was again 75, 75, and the total was 150. This is the tender in question. Now, 29th of May 2013, BFP, that is my learned friend client, they bid for 75, 75. Here, what is bid is what license fee you will pay. 75, 75 is not your discretion. Whoever pays the higher license fee gets the contract. Yes. 75, 75 is fixed for every bidder.
So what they will get out of it.
Yes. So whatever is the benefit is their profit. Now, on 9th of October 23, a circular issued by the railways where they say that instead of 2 meals, let first meal be regular meal and you charge 112, and second meal would be 66.5, which is combo meal, not a full meal, the dal chawal or rajma chawal, something like that. But the amount was increased to 178 rupees 0.5. That is overall, my lord, increase of 19%. Now, my lord, another circular, my lord, during the bidding period on 23rd of October 2013, my lord, where again, my lord, the same thing was, my lord, the amount remained the same, but they say no, serve both
Regular meals.
serve regular meals. So 112, 66.5. So earlier your lordships would find when they filed their bid, it was rupees 75 for regular meals. Now they are getting more, total 178.5, and they are supposed to give regular meals. Now comes the important date, my lord, for the purpose of our legal question. My lord, that is 17th of January 2014, letter of award given to them, accepted by them.
This 23rd October 2013 circular, does it also indicate the price there, or does it merely say that combo meal is to be stopped and regular meal is to be given?
The price also.
Price also. That is there at page volume 3.
Let me, my lord, it's a.
No, we just want to clarify that one aspect. Volume 3 then.
Yes, my lord, my instructions are, this circular dated 23rd October 2013 says that instead of the second combo meal, it would be regular meal.
Mention of the price there.
Price, but thereafter it was followed by.
Because here, the way you have indicated in the table, the price is also reiterated in the circular, which going by the judgment is not what I understood.
See page 163.
160.
Additional document 163. It's mentioned. Volume 3, page 163.
Yes, 163.
Your lordship.
Review. Yes, we've got it.
Lord, this is commercial circular number 67, corrigendum number 1, commercial circular number 63 of 2013. In view of the decision, kindly see 1, regular meal in place of combo may be restored accordingly, para 1.4 of the CC. But please see the last, that would be perhaps the answer.
Without increase in
Last but one, the above charges will be done without any increase in charges. I'm sorry, above changes will be done without any increase in charges.
Very.
So,
according to you, this would freeze the price.
Yes. So it would freeze, my lord, at 112 and 66.5.
Very.
Now, my lord, they accepted the letter of award at this price, 112, 66.5, total 178.5, and accepted both regular.
Let us see that document also. That's also in volume 3.
Yes.
Page 254.
54.
More or less illegible.
It is, my lord. It is, my lord. I am also struggling.
It's also in SLP.
Give me.
Congratulations for being qualified.
Your lordships may pardon me, my lord. I'll replace it, my lord, by the.
No, it's all right.
My lord, SLP page 155, my lord, is also typed copy. My lord, better your lordships come to page.
But here there's no mention of the price though.
My lord, there is a mention.
What you are giving them.
6. A copy of revised catering charges is enclosed herewith.
For your reference. So there is a separate revised catering charges. Is that also, that's not fine.
So it's P13 in the edition, in the same volume your lordships have.
Yes. Page 13.
Page 164.
In the third volume.
Yes. CM, MT, BF, my lord. ET is, my lord, evening tea. CM means combo meal. MT is morning tea, and
This is appended to this award letter.
Of the letter of award, my lord. So subsequently, there is a contract also entered into. Now, my lord, after this, they commence the catering services on 21st of January 2014. So this also date is not in dispute, my lord. On 21st of April 2014, master license agreement is entered into, where also the price of 112 and 66.5, but the total of 178.5 is mentioned and they enter into it.
Let us see that ML master license agreement.
Lord, it is at page 263.
This indicates the prices.
Yes.
See.
263.
263 onwards.
Lord, at
We're trying to.
My Lord, 1.4, your Lordship, get, my Lord.
1.4. Yes.
Is agreed by the licensee. Your Lordship gets, my Lord. My Lord Justice Sharma gets, my Lord.
Yes.
It is agreed by the licensee that the norms with regard to catering charges payable to the licensee for providing catering services to the passengers on the train are also subject to the predetermined prices as set forth in Annexure 2, which is the same as your Lordships have seen.
The Annexure 2 is missing again.
It's the same document.
It's not filed though.
It's the same document, my Lord.
Why is it that they don't file a full set of documents?
Can I file, my Lord, a convenience compilation, my Lord? I understand, Lord. I understand.
What we can't because Mr. Tripathi will have to confirm whether this was the document which was Annexure 2. How will we know?
May I suggest what I'll do is I'll take, my Lord, my written submissions back unless your Lordships have marked.
No.
I'll prepare a convenient compilation and give the pagination of that convenience compilation.
You already started.
But your Lordships may not give me back, my Lord.
It can be rubbed out. We use pencils anyway. Anyhow, you can continue because you have 40 minutes more, but we'll need full sets of documents, not this.
So I'll give, my Lord, with the written.
Why do you need? We kept this afternoon aside for you, Mr. Mehta. You can at least tell us what the case is and how you propose to go about it. We'll look at the documents as and when you do file them. So according to you, the master license agreement freezes the price and mentions it in Annexure 2.
Yes. Now, well, this happens after commencement of service and after 4 months. Your Lordships have noticed the date.
Very.
Right, my Lords? Now, Lord, during this period, they were billing as per, my Lord, this 178.5 and supplying the meals without any objections. Now, Lord, they file a petition. You are saying that.
You can take instruction. My instructions are that there was no Annexure 2 at all.
At all?
But I give it to my friend, they can check up. That's why I said it will make it easier. I'm not.
Let me check up. Let me check. No, you check. If there is a specific case, then we must check. We are before the court.
Matter of record.
It's a matter of record, my Lord.
Each page of the ML, what is it? MLA. Each page of it is signed or?
Kindly, my Lord, have it. There may be some other clauses, maybe. I have not seen the clauses in the master license agreement.
No, we are just verifying whether you took signatures on each page of the master license. Yes, each page is signed. So in all probability, if you had an Annexure 2, they would have signed on each page of that also.
Has to be. The license. So before making a statement, when they are disputing, we must be clear and we must say so on affidavit.
Yes.
So shall I start, my Lord, or verify?
That also you can verify and tell us. If there was no agreement, then what follows, then we'll have to address them.
Now, my Lords, may kindly come to Lord, 6th August 2014. One addition is made, and addition is that the railway say that you also serve one welcome drink. Lord, please see, Lord, page 4 bottom. Welcome drink was to be supplied to all the passengers whenever breakfast was immediately followed. After the welcome drink, Tetra Pak drink was not to be served with the breakfast, clause 1.6 and 4.1 summarized the position after Commercial Circular 67 of 2013 that meal 2 would be a regular meal supplied at the combo meal rate. My lord, that again, my lord, is reiterated according to me in 2014. Now, my lord, if your lordship would like to see the clause, my lord, it is at page 308 of additional document.
Page 308.
My lord.
This is
Volume
in
3, page 1.6.
Volume 3 only. 308. Yes.
Lord, as per instructions issued, your lordship gets, as per instructions issued with a CC 67 of 23, regular meal, lunch, dinner is to be served in place of combo meal wherever applicable at the tariff applicable for combo meal. Your lordship gets.
Where are you reading?
Page 308. This is government circular dated
6/8/2014.
At the foot, clause 1 point.
Instructions.
As per the instructions issued,
1.6.
CC 67 of 2013, Lord, which is, Lord, dated, your lordships may mark 23rd of October 2013, which I had shown to your lordships earlier.
No list.
Regular meal within bracket lunch, dinner is to be served in place of combo meal wherever applicable at the tariff applicable for combo meal. Kindly turn the page over, my lord. Lord, clause 4.1, last 4 lines.
Yes.
Payment of apportionment charges to the caterers should be made according to the actual services rendered to the passengers as per following rates given below, except in case of combo meal where charges will be as per below, but menus shall be as per regular lunch or dinner meal, lunch stroke dinner meal as issued with a CC 67 of 2013. It says the same thing, re-emphasizing the same thing.
Breakfast. Dinner. So the rate has gone up some more, is it? Lunch dinner is 145 now. I see. 145 is what you take from the customer, and 129.50 is what you pay.
Yes. Including service charge.
You're still mentioning combo meal though.
Yes.
But combo meal is not to be served.
Yes, combo meal at the combo meal is not to be served.
Regular meal is to be served at the same price.
The combo meal rate, that's what it is.
That is what you said in 1.6.
This is not in controversy also. Now, my lord, page 5. On 22nd of June 2015, Lord, their association makes a representation, but please note, they do not say any, they only say that please increase the rates. They are a member, they are in fact the lead member of the association. No claim against meals or drink already perpetually supplied till this point, nor any reservation of right to claim such amount. They say that now increase our amount. The amount remains same. The representation is this. This is to show acquiescence part. Then, my lord, there are 6 representation letters. Again, my lord, same thing. Please increase the prices, but no mention of what is to be done with the present supply. Now, my lord, 2017 we come into the picture. New catering policy 2017 was announced by the Ministry of Railway, wherein it was inter alia directed that catering services would henceforth be managed by IRCTC instead of zonal railways. That's the only change which takes place without changing the contractual terms or respective rights and liabilities. Now, my lord, a tripartite agreement is entered into. 10th August 2017, tripartite agreement executed between Chief Commercial Manager Northern Railway, IRCTC and claimant, whereby the management of the food services was transferred to IRCTC. Note, it is relevant to note that even at the time of entering into this tripartite agreement, the claimant never raised an objection or questioned the original letter of award dated 17/1/2014 and master license agreement dated 21/4/2014 and the figures mentioned therein. Now, my lord, your lordships would note they started supplying the meals in January 2014. They filed a writ petition in December 2017. The writ petition filed by the claimant against Chief Commercial Manager Northern Railways and Railway Board seeking quashing of the Commercial Circular number 67 of 2013. Your lordships have seen, my lord, that and 32 of 2014 and claiming consequential payment towards the second regular meal as well as for the welcome drink. Claim made for the first time after more than 3 years, seeking quashing of circulars and consequential payment. So Delhi High Court passed, that is 23rd of September 19, Delhi High Court passed the detailed judgment dismissing the writ petition and granted the liberty to the claimant to initiate arbitration proceedings. Please note, as I have said, even in the judgment of the Honorable High Court, the court notes that the claim is prima facie outside the limitation. Then, my lord, on 24th of January 2020, arbitration notice was sent by caterer to IRCTC claiming that they had been paid. Now, please note this, my lord, 112 plus 67.5 for providing 2 regular meals and sought the differential amount from 112 plus 112 as well as monies toward the welcome drink from August 24 to March 2020. They say that now since we have supplied 2 regular meals for the second meal, don't pay us at the combo rate, despite having accepted, I'm not repeating, in the letter of award, in the agreement, etc., etc. Now, my lord, pleadings in the arbitration, my lord, your lordships would find, my lord, I have quoted at page 7. Before I come to the pleading, let me complete the factual chronology, my lord. 27th of April 2022, impugn award was passed by the arbitral tribunal. The sole arbitrator awarded a sum of rupees 20 crores for recovery of differential cost for the supply of regular meal and rupees 5 crore for supply of welcome drink along with interest. The arbitrator accepted the claimant's contention regarding coercion by common finding for combo meal and welcome drinks. I'll read, my lord, that coercion, and your lordships are aware.
This is in relation to one of the contractors or for all of them put together?
There is only one contractor.
This is one contractor. Each one is getting about 25 crores.
That
seem to be multiple contractors.
Figure is approximately 75 crores.
25 crores.
But it's a 13 matter. 13 matter. Total figure is 75 crores. All the
how many contractors are involved?
3.
Three contractors. So roughly 25 per head. Starting up to 75.
Gets
I
less.
think so.
25 is our responsibility. Liability.
Very.
Arbitrator accepted the claimant's contention regarding coercion by common finding for combo meal and welcome drink claims in para 98, 99 and 104. All reasoning was contained in the lead award. The remaining 12 connected awards only contained train-specific computations while referring and relying upon the lead award for reasoning. Lord, we challenge it now before the learned single judge. The judgment passed by the learned single judge setting aside the arbitrous award on claimant's claim towards the combo mill. The learned single judge held that arbitrator's findings accepting claimant's contention of coercion to be patently illegal and perverse and based on mere surmises and conjectures. Then, my lord, both of us challenged the order and impugned judgment by the High Court, setting aside Section 34 decision insofar as it related to the second regular meal claim and reinstated the arbitral award on that issue. So I lost. It upheld both the Section 34 order and the award regarding welcome drink. However, it set aside section 34 order and the award to the extent they granted interest on the principal amount to the claimant. Then, my lord, I'll read, my lord, from the conclusions of the impugn order, my lord. But now please see first the findings on coercion. Because essentially for the purpose of, my lord, justifying delay and for the purpose of answering a potential question as to why you kept on supplying without a murmur, without raising any claim, without any objection, they resorted to, my lord, the pleading of coercion, and therefore your lordships would find at page 7, para 15, the lord, pleadings on coercion. Para 16, your lordship gets, my lord.
Yes.
After the commencement of the services, when the claimant tried to raise bill for the meal supplied at the regular rates for lunch and dinner, however, it was informed by the Northern Railways, the predecessor of respondent, that unless the bills were raised as per Commercial Circular number 67 of 2013 dated 23rd October 13, bills will not be cleared. So there is no bill raised. This is an oral that we raised the bill, we went and we were orally told. That's
nothing in writing.
Yeah, nothing in writing. The claimant resisted this and requested the Northern Railways not to do so since it was completely illegal and because the contractual conditions. The claimant being under tremendous financial and economic duress, since regular funds are needed for day-to-day catering services, expenses, and for the reason that the catering operation or services cannot be discontinued at any cost, was forced to raise the bills as per the dictate of Indian Railways, as otherwise it would be totally starved of funds, leading to a state of financial distress and unable to provide the catering services on day-to-day basis. In the master license agreement, there are grave consequences, including termination, forfeiture of security deposit, and blacklisting if there is any discontinuity in the catering services or if there is any deficiency in the quality of services to be rendered to the travelling passengers. Then, my lord, petitioner's statement of defense. My lord, this is how I deal with this. The contents of para 16 and 17 are wrong and denied in the manner in which they are stated. The claimant was required to submit bills as per the terms of tender and master license agreement or modified by instructions issued from time to time. It is stated that claimant itself submitted bills to Northern Railways in accordance with CC number 67 of 13 and payment was duly processed and made to the claimant. It is denied that there was any undue pressure exerted on claimant. It is denied that the claimant was forced to raise bills as per the dictate of Indian Railways. It is stated that present plea of claiming money for regularly is nothing but an afterthought, as evidently the claimant had no difficulty in performing the license in terms of payment determined by CC number 67 of 13 for a period of 6 years, that is 2014 to 2020. It is stated that claimant cannot be permitted to challenge CC number 67 of 13 after a lapse of 6 years and the said plea is barred by delay and laches. It is further stated that the plea of the claimant has been made at the present time with mischievous and malafide intent, and it is well aware that IRCTC has been entrusted with catering operations as well as assignment of old license under catering policy 2017, and therefore it would not be able to access old bills and transactions held between different zonal railways and the claimant. It is stated that claimant is an aware litigant who has been continuously raising even minor issues before different forums, either by way of arbitrations or before the Honorable High Court. The conduct of the claimant in failing to raise the issue of reimbursement of the alleged charges for a period of 6 years, either in arbitration or before the Honorable High Court, clearly points to the fact that present claim is at best an afterthought, seeking to benefit at the cost of state exchequer when payments have already made. Because he is having several other contracts also. This is not the only contract, and he is quite a litigating man. Now, my lord, what is the finding in the arbitral tribunal's award? That your lordships would find at page 8 at the foot, my lord. Para 98, 99 and 104.
Yes.
I do not agree that the claimants can be non-suited on the ground that they waived or abandoned their right to seek reimbursement for the cost suffered to make supplies. It is an admitted fact that tenders were issued prior to the commercial circular dated 23rd October 2013. Even the bids were submitted prior to this circular, which was at 150, lesser rate. I have no difficulty with this finding. Even though from the record it appears that the letter of award was issued later, but the respondent did not seek any consent from the claimants as regards to their willingness to supply regular meals at the price of the combo meal. I may observe that the present contracts are in the nature of commercial contracts where the parties have to incur cost for providing services, and therefore, unless proved otherwise, it cannot be accepted that a party would agree to provide services and incur costs and not expect to be adequately reimbursed. So I have to prove otherwise, that there was no duress or coercion. To put it differently, in case a party is pleading waiver, estoppel, and acquiescence, then the onus is on that party to establish the same, as otherwise in normal circumstances, given that the contract is of commercial nature for supply of services, a party is legitimate in expecting itself to be reimbursed for actual services rendered. Thus, I am unable to agree with the respondent that merely because the claimant raised the bills and accepted payments under those bills would itself amount to an act of waiver or abandonment or relinquishment of their rights to seek reimbursement if they are otherwise entitled. Not forgetting that during this period, not a whisper that I am doing it under protest or I am raising a bill under protest. You pay, you may not pay. Now, about 99. A perusal of the pleadings in the statement of defense in para 4, read with its written submission, show that according to the respondent, the claim is barred by waiver, estoppel, and acquiescence as the claimants have raised bills as per Commercial Circular number 67 of 2014 and have duly received the payments for each individual bill. I do not feel that this plea alone is sufficient to establish waiver, estoppel, and acquiescence of right by the claimant, particularly when the claimants have specifically pleaded in para 16 of the SOC, which I read before your lordships, that they are coerced to raise the bills in accordance with commercial circulars issued by the Indian Railways, and in case they fail to do so, no payment would have obtained by them. The claimants have also stated that they are in a financially precarious situation because they needed regular funds to maintain day-to-day supplies in the trains. I have no reason to disbelieve them. This is the finding. That the pleading is made and I have no reason to disbelieve the pleading, to disbelieve them. From the amount sought before this tribunal, it is clear that the claimants incurred significant costs in providing those services for which reimbursements have been sought, and I cannot persuade myself to believe that claimants, being businessmen working on competitive margins, would willingly render services without expecting to be paid. I may note that with regard to the regular meal supplied, the payment was being paid at the price of combo meal. However, so far as the welcome drinks are concerned, the claimants were not permitted to include the same in the bill, given the stand of the respondent that the same were to be supplied free of cost. It was a part, whether you like it or not, of the same amount. The claimants have invoked the plea of duress to contend that in case they did not act as per the diktat of the respondent, they would not be paid, which would have further compounded their losses. Lord, no oral evidence or documentary evidence led, and the only finding is that they have pleaded duress, and I have no reason to disbelieve. It's a commercial contract, and why should they not raise the bill now?
How did the arbitrator quantify the price for the welcome drink?
Lord,
while granting that,
8 rupees, Lord.
How? On what basis?
Lord, I'm told, Lord, I'm subject to my.
Because you did not say anything about a welcome drink price.
That tea was 8 rupees, so welcome drink also should be treated as 8 rupees. No proof, no evidence, nothing. My learned friend, I think, appeared. My learned friend appeared.
Number, in fact, the evidence is the person who came from doing oral evidence says, I do not know how many drinks have been. Question 35 of the cross-examination. He says, put in the written submission before the arbitration.
The chartered account.
Put in the written submission also question 35 is specifically relevant.
No, but the arbitrator fixes the price by going by the price of tea. This welcome drink is in the form of a Tetra Pak drink or Tetra Pak?
Fruity, it was.
In case it is given and it followed by a breakfast,
In the
Then
breakfast is not
in the breakfast, there should be no drink. So otherwise, the breakfast included a drink. No, but this welcome drink is only to be given on breakfast trains, or is it to be given?
Only when you board. When you board.
So even if it's a lunch time train, also you would still get a welcome drink.
Whenever you board, and you board once, obviously.
But in case it's a breakfast time train, then you would not offer it twice. You would give it to him, and thereafter it will be.
The breakfast would not include welcome.
No, the circular which you read out, Mr. Mehta, what you read out says that in case you give a welcome drink, you won't give it again at the end of the breakfast. Very.
There's no evidence about that. How many drinks served? How many breakfasts against the...
No, but how do you measure the number of meals given? Go by the number of passengers.
No, number of tickets.
Same thing would apply even for that then. If you go by the number of passengers and say that meals would be. No, but it's not necessary that a person will have a regular meal also. There are a lot of people who carry their own food on trains. I used to do it while I was traveling on trains. Yes.
Possibly because in our days, this services were not.
It was not on this level perhaps. You used to get some food, but not of very good quality.
Yeah, yes.
At that time, one chose to carry one's own food on the train.
In a tiffin, and there used to be, I don't know what is called, my lord, but bedding, a bedroll or something.
Bedroll.
Now, my lord, of course, they have.
Now everything is provided on the train.
Everything is provided and very well provided. I'm told the food.
No, these trains are supposed to be very high quality trains.
This 5-course meal. 5 courses. No,
5 courses.
Starts with when thereafter one after the other it is served. And it ends with.
And you're still paying them the same price?
It ends with what?
Ends.
What? Yes. Depends upon the timing.
Very.
Finalized and signed by the ticket checker. Because I bring that many lunches, I can't take them back and serve anyone else because they are dedicated.
You go by the number of passengers.
He signs it that so many have come, so many.
Passengers, so you bill them for that number of passengers because
assumed to have eaten.
He signs that I have brought so many. So
once you have that number of passengers, you will also have that number of welcome drinks. So you may take it back and use it again.
And you'll have inventories both ways, when you board and when you dispose. That is when the train ends. No evidence of that.
Lord, now we approach the Honorable Single Judge, my Lord, under Section 34, High Court. My Lord, please see the findings at page 9 bottom, para 72 of the Learned Single Judge judgment. The above narration of facts suggests that before accepting the letter of award and before entering into MLA, that is Master License
Agreement,
circular, were already in circulation and in knowledge of the respondent. The respondent thus entered into contract with open eyes, knowing that the rate of the first regular meal was 120 in 2A, second AC, 3 triple AC, so and so, and the second regular meal was 66.5, discussed in detail later. Clearly stipulated that petitioner had the right to modify or alter the catering tariff without consultation with the respondent. Hence, it cannot be said that the respondent had a right under the contract to claim the difference in rates specified in CC 63 of 2013 and 67 of 2013. The aforesaid clause covers those situations where there is a legitimate right of a party arising from the agreement which has been hampered. In the present case, given the contractual terms between the parties and the guidelines which were in force, BFP, that is my learned friend's client, had no legitimate right to make its claim. The arbitrator's reliance upon the representation of 2015-16 and the writ proceedings instituted in 2017 to state that this was not a case of waiver is perverse, since it is in blatant ignorance of the binding contractual terms between the parties. He has failed to consider that this was not a right which the respondent had in the first place. But as I pointed out, in the representation, they only said that increase our rates now.
Yes.
And it was a general representation by the association, not contract-specific representation. Further and importantly, for almost 1.5 years, that is from the commencement of services in 21st January 14 till 22nd May 15, when the first representation was made by Indian Railways Mobile Catering Association to the Northern Railways, no objection was raised by the respondent regarding the change in appropriate charges, in apportionment charges. During this period, the respondent continued to raise bills in accordance with the commercial circulars and continued to receive payments without any demur or protest or reservation. For the sake of repetition, circulars were issued in 2013, LOA was issued in 2014, MLA was entered into in 2014. However, till 22nd May 15, there was no protest by the respondent. The respondent has not been able to explain that why for a period of 1.5 years the respondent was providing 2 regular meals and was charging for the second regular meal at combo meal tariff. The arbitrator's finding that the bills were raised under duress, coercion, and because the respondent was in a financially precarious situation is not supported by any evidence. The arbitrator has erred in holding that because the petitioner had a dominant position in the contract, the respondent could not have easily surrendered the contract and had no other choice but to raise the bills and receive payments as per the commercial circulars. These are bald assumptions without any evidence to support the same. The arbitrator has already merely considered the pleadings of the respondent in statement of claim that the payment would have stopped and had they not raised the bills in accordance with the commercial circulars, and has held that I have no reason to disbelieve them. He has thus based his reasoning on mere surmises and conjectures and has observed that since significant amounts are sought, the respondent must have incurred huge losses. There is nothing on record to show the financial investments made by the respondent or that the petitioner was not ready to accept the bills which did not comply with 6cc, both circulars. Hence, in a nutshell, I am of the view that doctrine of waiver is irrelevant in the present case, as once BFP, that is claimant, entered into the contract with the petitioner, it did not have any right to seek a reimbursement of price difference for providing the second meal as per the charges stipulated in CC so-and-so. The conduct of the respondent, however, falls squarely within the definition of estoppel. The respondent signed the contract which permitted the petitioner to charge the tariff the respondent acted upon. The change tariff introduced with a commercial circular number 63 of 23, CC 67 of 23 and 32 of 2014, raised bills upon the change tariffs, accepted payments pursuant to those bills without demur or protest, and only after 105 years, it's issued a letter of protest. This is also not a letter of protest, I'll read. It's more a representation by all association, entire association, not with regard to any particular contract. If your lordships would like to see. For future contracts, not for the present contract. If your lordships may mark, I'll come to that. Annexure P18 additional documents, page 322. And this is not the only thing. There are multiple grievances raised by all members. Can your lordships, would your lordships like to see that?
You've got it. Volume 3.
I'm sorry, 323. Please see, the title. I'm sorry, 322.
Yes.
Kindly pardon me, it's a little.
It's a
provision for catering services in Rajdhani, Shatabdi, Duronto Express trains. Difficulties due to revision in menu of catering services. We, the Rajdhani so-and-so managing mobile catering services awarded to us under the new SBD guidelines, would like to bring to your kind notice that we are very much inclined to deliver and provide services without any complaint. However, in absence of any positive support from railways, it seems far-flung to achieve. The reason for stating so is based on the fact that various major issues are pending to be resolved by the railways, and in absence of those, we are not able to deliver as per the expectations of railways as well as the passengers alike. The first and foremost setback is in our operations is the enhancement of license fees by your lordships can skip that. That's nothing to do with the present controversy. Secondly, service of combo meals at 66.50 with reduced menu for Rajdhani Express trains in place of full regular second meal of the day was introduced in the year 2013. However, on account of hue and cry from the passengers, service of combo meal was stopped and regular meal service was reinstated. But the rates was not revised and was compelled to serve regular meal rupees 120.50.
Raise the issue.
Yes, my lord.
They raised the issue in the representation.
Lieu of combo meal, you're right. Chips are right. At rupees 66.50 only. Thirdly, railway board without animal rest is not relevant, my lord, cashew nut, etc. Fourth major change being done is the additional service of welcome drink to all passengers without any reimbursement.
Both issues are raised.
For the same, leading to increase in our per day cost. It is pertinent to mention here that services of welcome drink and additional item in high tea is being offered to the passenger without even charging for the same from the passengers. Sir, it is quite obvious that expectation of the passenger customers towards the etc. etc. My lord. Then perhaps, my lord. But my lord, fact remains that they raised this issue and continued to serve without raising bills at any additional rate. Now, my lord, we approach the learned division. My lord, may I continue, my lord?
We'll continue tomorrow afternoon. Afternoon, 2 o'clock.
Bench at 2 o'clock.
You have a special bench.
Yeah, my lord, 3-judge bench headed by my lord Justice Surekan.
Oh.
It's a part-heard matter, my lord.
That will go on for the whole afternoon.
Can it be on Thursday, subject to your lordship's convenience?
Thursday, I think. Thursday, I have a special bench. I have a special bench on Thursday afternoon too. These matters, I don't know whether. These matters, I don't know whether they.
Saying that I'll be there.
But these matters may not come up on a Thursday. Thursdays and Wednesdays are now reserved for final hearing. This won't come up also.
Final hearing.
And they'll go by the status of the case. It's an SLP without leave. Therefore, it won't.
Next notice is also not issued, but then that's okay. We can always, both of us are here ultimately.
Monday bhi hai na, fir it's the difficulty. So if not today, then we'll have to go to next Tuesday perhaps. 15.
And take a chance to
We'll keep it for tomorrow. In case that collapses, you can come back to us.
Not like that.
Bench is being constituted. Tomorrow is 22nd, isn't it? The Constitution bench is supposed to be sitting from tomorrow. Going by the news report, then
listed for the first time.
So it will get adjourned.
It's some procedural direction.
That may be so. That may be so.
I cannot say.
But this other bench is supposed to sit tomorrow afternoon, is it?
At 2 o'clock.
But anyhow, we'll just list it tomorrow. In the event you are held up, then we'll adjourn the matter. In the event that does not go on, you can come back to us. This tomorrow. The understanding that the matter would be taken up during the afternoon session.
State also.
It would be next Tuesday, hopefully. It's 29. We already have one hearing matter listed for 29, but three hearing matters. But anyway, we'll see how it goes. So tentatively tomorrow.
Please.